the participants, and I welcome on behalf of Institute of Insolvency Professionals, ICSI, in this webinar on drafting and negotiation of resolution plans. Today we have esteemed faculty with us, IP Ashish Makhija sir, to deliberate on the topic. I would like to read his brief profile before all the participants. He is a leading legal practitioner in insolvency and corporate law matters. He bears top credentials in corporate law, insolvency and bankruptcy law, corporate litigations and advisory. He was the standing counsel for the official liquidator attached to High Court of Delhi for 6 years. He regularly appears before Supreme Court, High Courts, NCLAT, NCLT, and arbitral tribunals in insolvency, bankruptcy, corporate law, and arbitration matters. He is a doctor of judicial science from Emory Law School, Atlanta, USA. He is a chartered accountant as well as cost and management accountant. He holds 2 LLM degrees, Master of Law in International Bankruptcy from USA and Master of Law from Kurukshetra University. He has the distinction of being World Bank trained corporate trainer. He is a master faculty and has spoken extensively on insolvency and bankruptcy code. He has served as a member of committee formed by Ministry of Corporate Affairs, Government of India for drafting rules for several chapters, mergers, revival and rehabilitation, winding up and NCLAT under Indian Companies Act 2013. So we welcome you on this session, and we are really privileged that you catered our request to be the faculty in this particular session. Over to you, sir.
Thank you, Surbi, for introducing me. I can see a lot of my old friends and very known faces. Yes, we are interacting after a very, very long time.
After a couple of months, sir. Good afternoon. Nice to see you, sir.
Yeah. It's always a pleasure. Friends, my only humble request today is, as I always say, that I don't want to speak to blank screens. So I think it will be good if everyone can open their videos. I think it will be fantastic. I would definitely like to interact because I don't only speak, I generally gain as much as possible from my right? So thank you so much, and please keep on opening your video so that all of us can see each other, and maybe we can have one screenshot also of all the videos open which are there. Okay. So friends, first of all, a very good afternoon to all of you. I think it has always been a pleasure to interact with each one of you at various times. I think we have been interacting since when the IBC came new, and we were trying to learn from that stage. And of course, now we feel that the law has developed quite a bit, and many things have settled. Of course, there are many issues which are still remaining unsettled, particularly in liquidation proceedings. Naturally, there are very few judgments on that aspect, and things are changing on a daily basis. Sometimes we see that also. Do we remember Vidarbha? Do we remember Rainbow? So things keep on fluctuating at many times, but I believe the Honorable Supreme Court is there to give us, the final, you can say, the settlement of the laws. But be that as it may, friends, let's start. This is a very important subject today, particularly drafting and negotiating the resolution plans. I think all of us will agree that resolution plan is something which is the heart and soul of the insolvency process, isn't it? If there is no resolution process, naturally the CIRP is considered as a failure. Even if there is a resolution plan, and it is not approved, then even then it's considered as a failure. And recently we have seen a circular by the IBBI, which is addressed to NCLT, that there has to be a change in the liquidator. The same person who was continuing as CIRP, as IRP or RP, should not be appointed as a liquidator. And in that circular, if you look at the reasons, the reasoning which they have given is that the fair market value I mean, the recovery in a liquidation proceeding is very low as compared to the fair market value. So probably nobody wants the company to go into liquidation, because once it goes into liquidation, as we all always say, it is always a distress value, isn't it? So we are able to recover only distress value, nothing more than that. So therefore, it is extremely important that the plans are prepared in such a manner and they are approved, and they will be approved, of course, as far as the business viability, as far as the feasibility is concerned. That is the call of the COC. It is not the call of the resolution professional. But I have seen, my dear friends, where the responsibility of the resolution professional comes is to examine that plan, is to examine and verify the plan. Now, that is an extremely high responsibility. And we have to check. And when we go through certain provisions, and I'll definitely take you to some of the important provisions, which actually calls upon the IPs to examine it in greater detail. Because liability, ultimately, you see, what we have seen over a period of time, the ultimate scapegoat is the RP. Whosoever may bring in a bad plan, but if the bad plan gets passed, and AOA is supposed to look at it, supposing any discrepancy still remains, the RP is always made the scapegoat. And this has happened in recent judgment of NCLAT. Of course, they did not pass any strictures against the RP, but definitely they wrote certain lines while rejecting the plans which were approved by NCLT. So these are certain circumstances which we are not happy about it. And we will definitely like to see that these do not happen, at any point of time with any RP. So friends, let's start, in the right earnest. I just need one or two volunteers to just read the IBC. Anyone who is ready to read it for me or for us? I mean, if you have the book with you, yeah, okay. I think Mr. Ajay Jan is there. Thank you, Mr. Jan. If you can just, I can see the book with you. I'm very happy to see the published copy with the people. Of course, nowadays we are also using the PDF formats. Yes. So these are very important portions which I'd like to read, and then we would like to interpret, and then we would definitely like to understand and also go towards the judicial precedents which are there. Definitely, there are a lot of guidance as far as the judicial precedents are covered. And you see, what I'm trying to do is, I'm trying to answer certain questions. And if you have any questions, then you can also raise those questions so that we are able to understand and we are able to discuss, because we are here to solve each other's problems to the best of our capacities. Like, there is one question which is in the mind of all RPs. Can a plan once submitted, can it be withdrawn? That's one bigger question, isn't it? We have always seen, because it takes 3 years time to approve the plan. And in the meantime, the resolution applicant who submits a plan, he develops cold feet, because the plan may not remain viable. That is also one of the important aspects. So that is one question which is in our minds. Secondly, a plan which is submitted, can it be modified before it being approved by the adjudicating authority, or at any stage for that matter? So see, these are some pertinent questions which we'll try to answer. Maybe you have more questions besides this. Then definitely we are going to look at it. But let's look at the structure, how it has been done, and definitely what are the case laws which are helping us to decide on these particular issues. Of course, we will talk about the drafting and negotiation. That's definitely a part of it. And what is the role of the RP in that particular circumstances? That is also very, very important. And we have also seen one more, trend, that while the plans are being considered, I mean, you have issued EOI, you have issued the evaluation matrix, you have decided everything. You have decided the list of the PRAs. They submit the plan. The plans are being considered by COC, and then suddenly the promoters also submit a plan and also file and want you to pursue 12A application, isn't it? We have seen that trend. And in some cases, they have been preferred also. Some benches have preferred it. that no, they can also be considered, they can come at any late stage. And particularly in case of MSMEs. Remember that siege on judgment of NCLAT, which of course it is under challenge. We have challenged that before the Supreme Court, but it is not coming up for final hearing. I mean, every time you see there is a delay in that, but that's a fantastic judgment to challenge. And in fact, when we presented it for the first time and at different hearings before the Supreme Court bench, the person who was the judge who was heading the bench, and he every time he remembered, yeah, this is a case which allows the backdoor entry for the promoters. Definitely, it's a fit case. We want to hear this matter. But unfortunately, because of the paucity of time, one way or the other, we could not do that. And now, of course, that honorable judge is also retired. It is relegated to another bench. So anyway, that's a part of life. We can't really do anything about it. But we are going to discuss even those type of issues also. So friends, let's do one thing. I'll request Mr. Ajay Jain to, first of all, open the definition of resolution plans and resolution applicant, which is 525 and 526. We have read it number of times, friends. But I think if you read it, if we read it together and in my style, so probably we'll have different meanings also, isn't it? So 525 and 526. Ajay ji, are you able to open
Yes,
your...
sir. Yes.
Yeah,
You are very much audible and clear, sir. Section 5, section 25.
Yes,
This
sir.
is called resolution applicant, means a person who individually or jointly with any other person submits a resolution plan to the resolution professional pursuant to the invitation made under clause H of section 2 of section 25 or
Yes.
pursuant to section 54K as the case may be.
Yes, obviously 54K talks about the PPIRP, but we are not really dealing with that. But the fact of the matter is that if we look at this difference, as far as the resolution applicant is concerned, now it contains two important things. And the opening sentence clearly says individually or jointly with any other person. So there can be a joint resolution applicant. Now the question that arises, you see, at many stages is that supposing today, one party, say X Limited, has expressed their interest that they want to submit a plan, and naturally they are considered as PRAs, right? Because based on the criteria which they are satisfying. And in one of the cases, this happened. They talked about a particular land. Now let's come out to the difficult situations also in this case. Why I'm mentioning this, can a joint resolution applicant be added at a later stage? This is the question which we are trying to answer, because it says individually or jointly. But should they be coming jointly at the first stage itself, or any other applicant can be added at a later stage? Now that's a question. That's a question which begs answer. And I'll give you one example, and then we will decide that how it happened. The plan was submitted by one of the resolution applicants of the prospective PRAs. And after that, what transpired, because by that time, even the RP was not aware, there was a land on which the building was built, right? So there were two parcels of land. One parcel was in the name of company, and second parcel was in the name of the promoters. And the building, the factory building which was built half on the company's land and half on the promoter's land. So it was a continuous building, and the plots were also contiguous. But the fact was 50% of the building was built on the company's land and 50% on the promoter's land. Now for the plan to be successful, tomorrow, if I approve the plan and go to NCLT and say that, you see, the whole of the land will come to the company, now that's not a correct thing. Without the permission or the consent of the owners, can you include that land in your resolution plan? And that's a big question. I'll come to that. Noida law and authorities also, because there is a lot of problem which is coming up in many cases, and we'll like to discuss, but let's discuss this first. Here, fortunately, the suspended directors who were also part of the COC, they understood, and they said, and they discussed informally with the resolution applicant, and he said, okay, I am ready to give my portion of land to the company at, say, certain consideration, but provided you make me as a part of the joint resolution applicant. Now, suspended director that was informally, not before the COC, because when this problem came. Earlier, of course, RP never knew because they were never not provided the you can say the copies of the title deeds, which land belongs to. Everyone was under the impression, and even the bankers never informed the RP that this land is in two parts. Everyone believed that this land belongs to the company, which happens at many times because of the lack of documents or something. So thereafter, there was informal discussion. And ultimately, they submitted a revised plan saying that this suspended director, A, will also be a joint resolution applicant. Now, the question that arises is, can such a person become a joint resolution applicant at a later stage? The
Yes.
answer is
if he passes the test of 29A.
Correct. Absolutely. 29A is the basic. So therefore, he was added as a joint resolution applicant, and the RP was advised to check 29A, which he did. And particularly because it was an MSME, so 29AC and 29AH were not applicable. So they were lucky that these two clauses were not applicable. So therefore, he was qualified to become, a joint resolution applicant. So that sorted out the problem. It was explained and discussed in detail with the COC, and COC members also appreciated the fact. And ultimately, there were two competitive parties which were there, and this plan was approved by the COC, which is now pending before the adjudicating authority. So, and there are many objections which have been raised against the plan, but this is not the objection. So that he has been made at a late stage. So this is something which is also possible, my dear friends, because we are not able to envisage certain situations at the initial stages. So this is one part. But the second aspect is, if we read the second line of this particular definition, and sometimes you see, if we read it too, you can say literally, then it becomes a problem at times. It says, such a person submits a resolution plan pursuant to the invitation which is made by the RP in accordance with section 25(2)(h). Now, 25, my friends are aware that 25 talks about the duties of the RP. And in one of the duties of the RP 25(2)(h), yes, Jan sir, can you just read it for the benefit of the all participants?
Sure, sir.
Yeah.
25A.
2H.
Sorry, 2H. Invite prospective resolution applicant who fulfills such criteria as may be laid down by him with the approval of COC, having regards to the complexity and scale of operation of the business of the CD and such condition as may be specified by the board to submit a resolution plan or plans.
Yes. So therefore, the point is, the plans are submitted by the resolution applicants only upon invitation being extended by the RP. Now, the question that arises, if there is no invitation, can somebody submit a plan? The answer is no, because the law says so. 25(2)(h) is absolutely clear. Who has got the responsibility to fix up what is the criteria? The criteria has to be established by the COC. We all know that what should be the net worth criteria, what should be financial criteria, what should be experience criteria. There can be anything. And then, of course, evaluation matrix and all, everything is decided beforehand, isn't it? So if it is decided by this, those resolution applicants who are submitting their EOI, now they have to be tested against those criteria, and naturally RP will do that. And RP after seeing that, yes, out of 10 people who applied, assuming 5 are satisfying that criteria, then he will extend an invitation that now please submit your resolution plan to those 5 people, isn't it? So extension of invitation is important, and that is done by way of, you see, the giving the list of the PRAs and then the final list and all those aspects which are there. So therefore, if I do not extend any invitation, RP does not, so can a person submit a plan? The answer is a big no. You cannot. In such circumstances, we have seen what? The parties are filing directly to the NCLT, going to the NCLT and saying, look, we should also be permitted to submit the plan. Though we filed an EOI, but later on we did not express our interest, I mean, this thing. So we did not deposit the EMD, but now we are ready to do it. And we have seen that NCLTs have also been liberal at many times to permit them. But the fact of the matter is, and in one of our cases, this exactly happened. One of the parties in a real estate did not submit the plan, and they went straight to the NCLT. And in fact, they submitted their plan itself in the NCLT. Now, NCLT could have rejected on the basis of our argument that 25(2)(h), though no invitation was extended, and they were not qualified also in any case. So why you are considering their plans? But at the end of the day, they asked the RP, they said, okay, you have received 2 plans, and this is the 3rd plan. Why don't you compare the 3 plans and give us a complete statement? So we made an Excel sheet of running into 30 pages. They're saying that their plan is bad. So then they said, okay, so your plan does not match this. The other plans are better. So therefore, your plan will not be considered. So friends, these kind of things, of course, these are exceptions. We can understand the benches doing like this, but at the end of the day, we must see that these all things are followed, you see, properly. So this is one of the important aspects which I wanted to bring about in your notice. And then let us look at the resolution plan definition now. Yes, sir. Can you just read 526, sir?
Yes, sir. 5 subsection 26 says about the resolution plan. Resolution plan means a plan proposed by resolution applicant for insolvency resolution of the corporate debtor as a going concern in accordance with Part 2. Explanation. For the removal of doubt, it is hereby clarified that a resolution plan may include provisions for the restructuring of the CD, including by way of merger, amalgamation, and demerger.
Yes, this particular explanation, my dear friends, it was not there. Probably it was added in the month in 2019, if I'm not wrong. So, because earlier it was silent whether it can include the restructuring or demergers, mergers, amalgamations. And this particular explanation was added in 2019, much earlier. Now, of course, it's almost 4 years now. But if we look at this definition, it says resolution plan means a plan proposed by the resolution applicant. Naturally, resolution applicant will propose it. But the question that arises is, again, because we are you see, playing with the words. The definition says plan, which is singular. Can there be 2 plans in a company? And particularly for a real estate project, supposing you have got 5 projects. Can we have
as per recent development in the as per judicial precedents, yes, it can be submitted for different projects. Resolution plan can be submitted for different projects for the same CD.
No, Mr. Ajajan, you are referring to Supertext case. That is a different issue, and we'll talk about that also. But the point is, I'm talking about in the normal course. Like supposing the company has, I took an example of real estate because it is much easier to understand. Like supposing there are three projects in a, you see, a real estate company, and there are different places and at different stages of construction and of different nature. Could be commercial, could be residential, could be any other thing. So in such a case, now supposing a local local developer who is there, say in Bangalore, will he be interested in a project in UP? Will he be interested in a project in Mumbai? Supposing company is having 3 projects at different places. So the answer is no. So what happens in that case? Then, so if we are saying resolution plan for a corporate debtor, then a single person has to submit a plan for all the projects. So therefore, law is silent, my dear friends. Let's admit that. It talks about resolution plan only. But if I attach this with the General Clauses Act, and General Clauses Act says a singular word will always mean the plural. Singular always includes plural.
Correct.
Plural includes singular, right? Wherever supposing the law says plan, so naturally plans can also be interpreted. So anyway, that's too technical. But the fact of the matter is, at the end of the day, idea is that the company must survive, that the plans must be approved. Though the law is not clear, we should actually make provision for that. It will make life easier for the corporate debtor also, because we don't want the entire company to go into liquidation. If we can save, say, companies dealing in steel industry and companies also dealing in cement industry. Somebody wants the steel industry, steel plant, but does not want a cement plant. Should we not permit it? Law at the moment, if you read it, it does not, because it says resolution plan for the corporate debtor. That means there has to be a one single plan. There can be multiple people filing the plan, but it should be for the entire corporate debtor. This is our belief. But what we did, you see the same thing as Mr. Ajay Jain is mentioning. Now, what happened in 2018, we were advising one of the RPs for the real estate matter. Same thing, 3-4 projects, and he published EOI for 2 times. No plan came. Nobody even submitted EOI also. Then ultimately, when he was making the 3rd attempt, the home buyers from different projects also came to us for legal advice. And we ultimately decided, and I gave them an advice, that this time you publish Form G asking for the plan for the entire company, corporate debtor, and also individually for the projects. Supposing somebody wants to submit only for single project, let them submit. Or somebody wants to submit for 2 projects out of 3, let's do that. The question which was asked by the RP to me was that, sir, can multiple plans be permitted? I said, the law does not say so. I agree. There is no quarrel in that. But let's set a precedent, because the law is evolving. And what we did, we got 3 different plans from 3 different projects. I mean, for a single project also we got 2. So obviously, naturally, the best of that will be taken up, but we got different plans for different projects. Somebody submitted for 2 projects, somebody submitted for single projects. Ultimately, in that company, my dear friends, 2 plans were approved by the COC. And COC also asked the same question. They said, can we approve 2 plans? I said, yes, you can. And they did that. Now the question is whether adjudicating authority will approve it. So we filed the application. The first question by the Delhi bench to me was, Mr. Makhija, is it permitted? I said, yes, sir, if it is permitted. He said, tell me how it is permitted. Then I took him to this application, quoted General Clauses Act, quoted the explanation, because by that time the explanation had already come, because submission and approval by this, you see, takes little time. So therefore it was being considered. And then if you go to the regulations also, I read through all the regulations. I said, read this regulation, which talks about the mergers and other things. And ultimately the judge was convinced. He said, yes, it is possible. But by that time the plan could be approved. Unfortunately, the sitting member, he expired. Now, so he was in a mood to approve it, but and the arguments were also heard. The order was reserved, but ultimately the order could not be passed. So new bench was constituted. Again, the same question. I had to convince that bench again. And ultimately, my dear friends, in 2020, we were successful in getting approvals, one after the other, for 2 resolution plans in a single case. Now, those 2 plans, for some other reason, they have been set aside by the NCLAT, not for this reason. In fact, NCLAT also asked, and they were very happy. They said, yes, this is a good trend. And that is why we are seeing that trend now, like in Super Tech or in some other cases also, including that reverse CIRP and all those concepts which are also coming. And there is a recommendation by the real estate panel also that project-wise CIRP can be started, project-wise CIRP or plans can also be submitted. So therefore, now the government has taken notice of that. We may see some kinds of amendments. In fact, for real estate, they have recommended that NCLT should not be handling all this. Let it be referred to the under RERA only. Anyway, that we will see what happens. But at the end of the day, all I'm saying is that please do not be bogged down by a single thing. Sometimes you have to set a precedent in certain circumstances. Law is not very clear on whether 2 plans can come, but we did that and we have been successful in doing this. Now, there is a third very important aspect, which probably you are aware, but there is a controversy and many times it gets raised. I will request Mr. Ajay Jain to now come to 25(2)(I). Please read 25(2) clause I.
Yes, sir. 25 says duties of the resolution professional. Now I am reading 2I. For the purpose of subsection 1, the resolution professional shall undertake the following action, namely I. Present all resolution plans at the meeting of the COC.
Correct. And now please read section 30, subsection 3. Now, friends, here let us understand what 25(2)I says. It imposes an obligation on the RP to present all, underline the word all resolution plans before the COC. Now let us come down and read 30 subsection 3 because there is a slight contradiction. Yes, sir.
30 subsection 3. The resolution professional shall present to the COC for its approval such resolution plan which confirms the conditions referred to in subsection 2.
Right. So here subsection 30, subsection 3 of 30 says that the RP shall present before the COC such resolution plans. The word is such. Underline the word such. Such resolution plans which confirm the conditions referred to in subsection 2. And we know that in 30 subsection 2, there are a lot of conditions which are there, right? They go up to F. There are F conditions, six conditions which are listed there. So now here is a controversy. 25(2)I says RP should present all resolution plans to the COC. 30 subsection 3 says such resolution plans which conform to section 32. So now the big question is, what should the RP do?
Subsequent provisions will prevail over the previous provision. That subsequent provisions is section 30 subsection 3 which will prevail or which will supersede the previous provisions.
No, that is not, you see, I will say, Mr. Jain, that is not the judicial way of looking at it. It is nowhere provided. Let's take it out. Later law may prevail over a previous law, that we can understand. But the later section prevails over a previous section, that is no legal jurisprudence. I slightly beg to differ from that. Anyhow, let's understand that. The point is that what it depends upon the role of the RP. It also brings out what is the role of the RP. Now, as a role of the RP, let us understand in a broader term. Forget about the law right now. What is your role as an RP? Do you approve the plans? No.
No, duty bound to present all resolution plan before the COC.
That's what we are trying to discuss. So number one, we don't approve the plan. It is to be approved by the COC. So therefore, we are as RPs are only facilitators. But then it is also our duty to check the plans, examine the plans, verify the plans. So what to do? So the Supreme Court, you see, dealt with these two contradictions, which are inconsistencies within the law. And I think my friends are aware when there is an inconsistency within the same law, what do? We use harmonious construction as a rule of interpretation, right? The courts always try to read it harmoniously, that one is not contradicting the other, but then they are talking about the same thing. So what the Supreme Court now, and that judgment is a very old judgment, ArcelorMittal versus Satish Kumar Gupta, 2019, 2 SCC 1. Ajay ji, can you just write it on the chat box, the citation? 2019.
Just a moment.
Yeah, for the benefit of everyone, because I don't have a PPT today. Maybe some portions are there, but
SCC 2019.
No, 2019 within
yes.
Then 2 SCC 1. Okay. I think my friends are aware how to read these citations. 2019 refers to the year. 2 is the volume number. SCC stands for Supreme Court cases, and 1 is the page number. Right. So this is the way we read it. 2019, 2 SCC 1, ArcelorMittal versus Satish Kumar Gupta.
Yeah, now, I have said in the chat box.
Yeah, that's all right. So thank you. So in that particular judgment, they also, you see, have mentioned and they have discussed this aspect. And they said, yes, it seems to be contradictory. But then they have actually elaborated the role of the RP. So that's a good judgment for you to read, to see, to refresh yourself as far as the role of the RP is concerned. They said, look, all the plans which come it is important that they should be placed before the COC. But then it was argued, sir, if it does not satisfy or meets the criteria, conforms to the criteria, then what it should be done? He said, you are right. Some plans may be faulty plans, maybe not, aligning with the law, that is particularly section 30 subsection 2. But in that event, RP is supposed to prepare a due diligence report or a report that, look, this plan filed by so-and-so resolution applicant does not satisfy section 32 A, B, C, D, E, F, whatever, it is not there. He says it is for the now COC to consider and negotiate. So friends, I'm coming to negotiation also, drafting and negotiation. These are two important things. Drafting, we are not involved, but we are involved with the viewing of the verification. So they say the plan needs to be negotiated by the COC only. Now, what I can give you one example. I think we will all understand from where the Supreme Court is coming from.
Sir, sorry for interruption.
Yes, sir.
Yeah, you are saying these two inconsistent sections. One is section 32, the other is section 25(2).
No, I'm saying 33 and 25(2)(I).
Okay, thank you.
Okay, 33, sir. Subsection 3. Okay. Okay. So 32, of course, there is no controversy. It simply says that you have to, the plan should conform to that. But the question is whether all the plans which do not conform to 32 should also be placed before COC or not. That's the question, because 33 says only those plans which conform to 32 should be placed. That is the controversy. So here the Supreme Court says, and let us take an example. Supposing a plan which is, supposing there are two plans which have come. One plan which is totally compliant, the total resolution plan value is say 50 crores, 50 CR. One plan which has been submitted is not compliant, say in terms of 32B, right? Because 32B says that in case of the operational creditors and in case of the financial creditors not voting for the resolution plan, they must be paid minimum value in accordance with section 53, so and so. I think we are all aware of that. We will talk about that in a little while. Supposing that plan is not satisfying that criteria, or the plan is not writing that all CIRP costs will be paid. There is only one defect in this plan. Now, but overall resolution plan value says 60 CR, 10 crores more than the other. So here in this situation, both the plans with the report of the RP will be placed before the COC, and it is for the COC to negotiate. What is the negotiation? They will call that person who is not satisfying one of the criteria, and they can always talk to them and negotiate with them and say, look, your plan is better than the other one, but you are not satisfying this criteria. If you modify this clause, it is likely that your plan can be approved. Because modifications and changes are allowed, isn't it? The plans, I mean, you can always submit a revised plan. So therefore, the revision is possible. So in this situation, this is the objective, this is the logic from where the Supreme Court is coming from. He says, you are right that, okay, only those plans should be submitted, fine, that's all right. And naturally, COC cannot consider for voting any plan which is not conforming with 32. So it is their duty. So Supreme Court has shifted the responsibility on the COC that, look, RP has done his verification. He has submitted a report to you that this plan does not conform. It is now your duty to negotiate and get it confirmed. But you will not vote this plan for approval unless it confirms, despite the fact it may have a higher resolution plan value. But it comes under negotiation. So therefore, the value of negotiation is also there. Because ultimately, IRP is not taking responsibility for approval. So this is a good judgment for that matter, because it delineates the role of the RP. And they say role of the RP is only a facilitator. He is not the approving authority. If a bad plan is approved by the COC, let them bear. But at the end of the day, the plan must conform to all these things. So it is our duty that, number one, resolution applicant satisfies the criteria of 29A, because this is extremely important. And that sometimes also creates a lot of issues, lot of issues. Let me give you one example, friends. And so food for thought, and I would like to have your views. and this is something I will not name the company, I'll not name the RP, but there are IBBI has started proceedings against one of the RPs on this particular aspect. One of the one of the resolution applicants was the suspended director. Being NPA account, the suspended directors were not qualified, were not eligible under 29AC. But all of us are aware that if 240A compliances are there, like supposing the corporate debtor is the MSME, then 29AC is not applicable. So therefore, the suspended director submitted the plan. And it was the duty of the RP to check whether the MSME certificate is there or not, isn't it? And the law is now very clear, friends. Please understand one more aspect, because there are a lot of doubts in this. For application of 240A1 read with 29AC as to the eligibility of the RAs are concerned, we must see that the corporate debtor was having an MSME, was an MSME on the date of the insolvency commencement date, ICD. A registration obtained after ICD will not be valid. There are judgments to that effect now, right? So the person will not become eligible if the registration is taken later on. It must exist on the date, and it is not that it should exist on the date of submission of the plan. No, the cutoff date remains the CIRP date, which is ICD. Okay, so I hope I'm clear on this. So in any case, this question was asked. They said, okay, if you say that you are eligible, now show us, because when I took the possession of the records of the company, well, I did not find that certificate on record. And the person concerned, he gave him a certificate which was issued in 2017. And it also mentioned that the company is an MSME since 2007, because the old certificate number was also mentioned in the certificate which was submitted to the RP. Well, and the certificate was submitted on the affidavit. So on the basis of that, they said, yes, you are eligible, you can submit the plan. COC was also informed of the same thing, and then COC approved the plan. Now today, what has happened, my dear friends? In a very unfortunate turn of events, that plan is still pending for approval. And similarly, as one of the persons has raised an objection that the company was not an MSME, but when this certificate was produced, the bench said, yes, there is a certificate. But unfortunately, what happened? That person also filed a complaint with IBBI. Now, IBBI sent an email to the MSME department, to the MSME ministry. And MSME ministry gave an information, sent a reply saying that the certificate which was issued in Mr. Vikram, can you just mute yourself, sir?
Host, please mute Mr. Vikram, or if you can add me as a co-host.
Okay, so now he's muted. Thank you. So they sent an email, and do you know what is the response? What was the response? The response which has been received by IBBI is that the certificate which of MSME which was issued on October 27, they're not challenging that certificate. But they say it was cancelled in December 2017. Now, my dear friends, tell me how far the RP should go. If somebody produces a certificate, should we believe it or not? The person is on affidavit on saying that this is a certificate and the company continues to be an MSME. Now, I am told that if you go on the MSME's website, there is no data as to the cancellation or as to the registration of the. Can you check that this company is an MSME or not on the website? The answer is no. There is nothing in public domain. So now all I'm saying is we are going to fight it out, defend the RP. That's a separate issue. All I'm trying to say is this. It raises a very big question. At the time of the resolution plan, there are hundreds of documents which are submitted, like balance sheets, maybe net worth certificates, maybe hundreds of other documents. And you also take in your possession a lot of documents. Are you supposed to verify now each and every document, the authenticity of that document? Whether that document is like, supposing somebody gives you a lease deed. Yes, the company is the owner of, a company is the lessee of this particular land. There is a lease deed. Will you verify that lease deed is genuine or not? I mean, are we there to investigate? Definitely some sort of, if the document causes some cause of suspicion, I can understand that if you feel ke yaar ye document genuine nahi lag raha, that is all right. I mean, then there is a doubt. But if there is no doubt, do we wear the hat of and become a CBI and start investigating each and every document, my dear friends? Well, friends, this is going to create huge problems. So therefore, anyway, we are answering those queries from the IBBI, but I don't know what is going to be the fate. But this is something which I wanted to bring to your notice. So all I'm saying is be careful. This case teaches us that we have to be extremely careful as far as the document submitted by any damn party. We must take steps.
So then we should write to MSME.
Sir, that is all right. Today we are learning that. So supposing you write to MSME, it was written by IBBI directly to MSME. So therefore they answered. For government to government answers you can still get. But in fact, they answered after 3 reminders from IBBI. Can you believe this? आपके ईमेल को कौन पूछेगा सर?
सर वहाँ पर्सनली भी जाओ तो कोई नहीं पूछता है.
But you are right to that extent that if I do that exercise, at least it goes to my defense. Right? Tomorrow I can show to IBBI, say, I asked for this, they never supplied that information. इससे ज़्यादा तो नहीं कुछ कर सकता ना. मैं उनको बार 3 बार रिमाइंडर भेजूं और जब तक प्लान ही नहीं अप्रूव होगा फिर तो there is nothing can be done. So, I mean, all I'm giving, this is only one instance, sir. We are not going to learn only for MSME, but I'm saying there could be other documents like leasehold documents, could be rental documents, could be title deeds, could be any other document, isn't it? Even bank statements can be fuzzy. What do you do then? So therefore, my dear friends, please take precautions. That's what I'm saying, right? Make it a habit, make it in a standard operating procedure as far as the important documents are concerned that we are going to, check about it. That's all. Go for see the genuineness of the document, because the frauds are happening day in, day out. Now, who is the scapegoat here in such a case? RP, because IBBI says you did not conduct due diligence.
Everywhere RP.
Arey bhai, is it a part of due diligence to check the genuineness?
Not at all. But
and that too, when it doesn't create any doubt. See, I can understand if it creates a doubt. Naturally, we are all experienced people, and we know if this document is good or bad. I think dekhte hi pata chal jata. So if the doubt is there, naturally we'll have to do it. But if there is no doubt, then why should we go into such kind of things?
Please guide what would be the general precautions that what do you take while checking this? Besides taking affidavit, shall we do anything extra?
Yeah, see, all we are saying is that naturally the RP took that precaution that please submit it by way of an affidavit. So today, what we are representing to our IBBI also is that somebody submitted an affidavit, and along with that, the document was submitted. I relied upon that. Don't hold me guilty. Hold that person responsible, that he's submitting a forged document to me. So, but all I'm saying is this, my dear friends, that if any important document is there, like MSME is a very important, registration is an important document to see the eligibility, and you have an authority. Now, IBBI can come back with a counter argument and say that, look, as per section 17, you have all powers to write to any government authority, including PF department, income tax department, or any government department. Why didn't you do that? That was a part of your duty. So now something new is coming up today, isn't it? So, but all I'm saying is, I've not mentioned this case just to scare you, but all I'm saying is that please take as much precautions as possible. Add in your standard operating procedures for conducting CIRP or liquidation that you also need to check genuineness of important documents, not every document. We can't do that.
Sir, manufacturing of fake documents is a big industry in India.
No comments, sir. No comments. But yes, that is what I'm saying. We have to be careful. Today, actually, the problem is we can't believe anyone.
If Udyam Aadhaar is expired after CIRP, then what can we do?
What is expired, sir?
Sir, Udyam memorandum certificate.
No, that doesn't expire. No. Why does it expire?
Sir, I have seen an Udhyam Aadhaar memorandum certificate is valid 30 June 2022 and the CIRP date is 21.
Okay.
After CIRP, the Aadhaar has been expired.
Aadhaar has expired.
Udhyam Aadhaar memorandum, UM certificate, MSME certificate.
Okay. Is anyone able to answer that? You see, how come the certificate expires? Because see, the point is, you are now. I have taken another stand. I'm telling you now. What has happened is now I'm taking a different stand than IBBI. I've told the IBBI we are trying to defend that. Of course, whenever the hearing comes, we'll argue it. We are trying to tell the IBBI, number one, where it is written that registration is mandatory. Let us go to section 240A. Yes, sir. Mr. Jain, can you just go to section 240A, subsection 1? Just read that. And I'll show you my interpretation and also the argument which I'm going to build. I don't know whether I'll be successful or not, but it is my duty to defend the RP. So now let's look at 240A, sir.
Section 240A.
Yes, sir. 240.
Okay. Yes, yes. Just a moment.
Yes, sir.
Sure.
Have you got it, sir, or shall I read?
Yes, yes. Just a moment. Yes, 240A. Application of this code to micro, small, and medium enterprises. Notwithstanding anything to the contrary contained in this code, the provisions of clauses C and H of section 29A shall not apply to the resolution applicant in respect of CIRP or PPI, pre-package insolvency resolution process of any micro, small, and medium enterprises.
Yes, sir. Just along with this, sir, read the explanation which is at the end. At the end of this, you will find some
explanation. For the purpose of this section, the expression micro, small, and medium enterprises means any class or classes of enterprises classified as such under subsection 1 of section 7 of MSME Development Act 2016.
Yes. So here the explanation very clearly says, my dear friends, that MSME, which shall mean a class of the enterprise or class of companies which are classified, underline the word classified as MSMEs under section 7.1 of MSME Act. Now, if you read MSME Act, my dear friends, there are two sections. Section 7 talks about classification. Section 8 talks about registration. So I am presenting before the IBBI is that only a classification is mandatory. The registration is not mandatory.
Correct interpretation.
And regardless of the fact that this certificate has been cancelled or withdrawn, the company, the corporate debtor continues to remain classified as MSME because it satisfies the criteria which was applicable at that particular point of time, 2017, 18, whatever time was there. And I'm satisfying, this corporate debtor satisfies that criteria. So I'm still classified. Registration is the next step. So and your section, your definition also says you must be have the classification. So I can classify. So classification is different step than the registration step. So cancellation of registration does not matter because it has been cancelled for a very different reason, and the reasons have not been given. When the RP went back to the suspended director saying that, sir, this was cancelled, you did not inform us. He says, I also didn't know. The department never sent me a notice for cancellation. They are supposed to give me a opportunity of hearing also before cancelling it. He says there is no communication. Now that of course goes into a spin, but ultimately RP becomes the scapegoat for all these things. So anyhow,
here, sir, what I understand, it means MSME must meet the criteria of MSME as per section 7 on the date of ICD.
Correct. That's what I'm trying to argue the whole matter. Because of another reason. Do you remember when we were when a new concept for that PPI RP pre-packaged insolvency process also came? Now, there was a question, and that law was silent. They said whether you should obtain registration is mandatory to fall under PPIRP or only a classification is important. And I had mentioned when IBBI officials were also present in that webinar, and I mentioned that your law is silent, registration is not mandatory, simply a classification under section 7 is important. And all of them agreed. All of them agreed that yes, registration is not mandatory. And FAQs issued later on clearly said registration is not mandatory. So taking a cue from that also, and also in this particular section, I believe I have a case for argument. Of course, I don't know whether I'll be successful or not, but I'm trying to defend the RP in whatever way I can. Okay. Yes, Mr. Ravichandran, you
Sir,
want to say something?
good afternoon, sir. Sir, actually, this classification, I thought I could just share my experience to the forum.
Yeah, please.
In one of our case, what happened, sir? The income tax returns were not filed for many years. And of course, the GST returns were filed. So the stand, what we took it as that, the MSME, it calls for the WDV as per Income Tax Act, the plant and machinery value, the 50 crore threshold. Right. So since the income tax returns were not filed for many years, it cannot be classified as MSME.
Right.
This is the stand we took it, sir. So the persons who taking that whether it's a MSME or not should check that whether the company has filed the income tax returns as late as, latest as possible.
Okay. See, that is all right, but filing of income tax, can you explain how does it impact the?
Sir, I can add a little on this.
WDV.
Ravi sir, one moment. See, there is actually a checkbox in the MSME application. If you do Udyam registration, there is a checkbox to say whether IT return has been filed or not. The checkbox you will take to say yes if you are an existing MSME.
Right.
You don't take when you are a newcomer, because new enterprise would not have done the income tax registration, rather income tax IT return filing. So they will say no and they will move on. So which means the data for the WDV can be entered, manually entered. Whereas when it is an existing company.
Okay. So I got it. So therefore the criteria for investment and other thing, it can be borrowed straight away from the income tax department if you have filed. Okay, I got it. Okay. That's all right. Okay. So that is one part. I think that's also interesting, perspective which has been brought in by Mr. Ravichandran and Geeta ma'am. I think this is something where we learn together. That's very important, friends. So anyhow, this was only I wanted to share. I don't want to say too much on this because the matter is still going. It is a sub judice matter, so we don't want to debate too much on that. But I mentioned it only as a word of caution, that please do not take any document on its face value nowadays. If it's an important document which can turn the whole thing, like eligibility is something which will turn the whole things 180 degrees. So therefore it can become a problem for you. So please do not take any document. Take as many precautions as you can. Get an affidavit, get it notarized, document, check it if you can. So please do those kind of precautions which are there. Okay. So let's move forward, friends, or anyone who wants to share an experience or has any questions so far. I think we have discussed few issues. Okay. If there are no one, so let's move forward. Now, let us look at the basic requirement of the resolution plan, which comes from section 30. Let's try to, look at few parts of it. I'm not going to read because it's not an academic session for that matter, but I will bring in the practical perspective also along with this. So Mr. Jain, can you just open section 30? And friends, section 30 subsection is very simple. Yeah, it simply says that the plans must be submitted on the basis of the IM. Now here comes another responsibility. If your IM is not correct, then the person concerned can say, oh, the IM was not correct, therefore I submitted a wrong resolution plan. And this has happened in few cases, isn't it? This has happened in few cases where the resolution applicant withdrew and their plan was approved. They refused to implement it. And when the question was asked to them that why you're not implementing, they said, no, RP is responsible. They gave us a wrong information in the information memorandum. We submitted the plan. When we took over the company, these facts were different. So we are in trouble. So ultimately, even after the resolution of the plan approval, well, the scapegoat was whom? The RP only. So therefore, friends, we have to be extremely careful when we draft our information memorandum. So give as much information. Now, one more thing which I can tell you here. Do you remember that KV developer's judgment of NCLAT? Particularly in a real estate matter. This has come, I would not say recently, it's almost now more than 6 months now. What happened? And real estate is a huge problem, and many questions do come to me, you see, for real estate. The question that arises is, supposing there are 1,000 allottees, you invite claims, only 500 file, 500 allottees do not file. Should I admit the claim of the rest of the 500 without the claim form, or should I not as an RP? The answer is clear. We will not admit it without the form being submitted to you. That is clear. Somebody has to submit a form, only then you will start processing it and admit it. Or I would say collate it, not admit, I'll say collate it, okay, or accept it. The second stage, KV developer of NCLAT says, now that's a big problem which has come in. There are 500 home buyers who did not file the claim. That's a big chunk, even if it is 20%. Supposing I have paid and all the home buyers have paid 1 crore each. And supposing 200 people have not filed, so it's a question of 200 crores. It's not a small amount. Can that amount will go away? I mean, looking from an emotional point of view from the, you see, home buyers, it's their hard-earned money, put it into the company, and they do not file the claim for one reason or the other. Maybe they are abroad, maybe they don't know, maybe they are illiterate, maybe it's any other reason. Can their claims, and supposing a plan is approved without their claims, what will happen? Will they get their flats or their money back? Or it amounts to haircut?
RP needs to.
Sorry?
I think RP needs to disclose entire things that they have not yet filed their claims, but their claims are existing in the books of CD. So the resolution applicant has to take care about this thing also.
Yes. So this is one part of it. This is what the KV developer also says. So what is the duty of the RP in such cases? And we can take this, we can extend this argument to you can say real estate companies also. So what happens is, in this case, in the information memorandum, if you have a data, so first you have also to have a data, how many allottees were there, because sometimes that data is also not available because the promoters are in jail, they are not cooperating, you don't get any damn thing. So what do you do? So anyway, if you have the data from any source, here in one of the cases, the RP had the data given by the bankers, given by the EOW also, because EOW were doing some criminal inquiry and they forwarded that. So some data was available with the RP. So naturally, if out of 1,000 people, only 500 creditors, and now I'm expanding this. Now I'm not talking about real estate. I'm talking about all creditors now in a normal company also. So if there are total number of creditors are say 1,000, only 500 claims are received, 500 are not received. You will not admit it. That is very clear. But in the memorandum, in the information memorandum, you will mention that as per the books of account or as per the information or data available with him, provided from any other source like EOW or whatever, you have to mention that. Please be truthful everywhere. So in fact, the KV developer says it was the duty of the RP to write down, in fact, mention that look, these people have not filed the claim. And then they are going one step further. They say even those home buyers, because this is only in respect of home buyers, I can't extend this argument to the others for the second part. For the first part, it is the duty of the RP to disclose what are the liabilities as per the balance sheet or as per the books of account, which is available with them. Don't hide anything, my dear friends. Be upfront, make available all the documents what are you in custody to the RAs on the virtual data, whatever you want to give that. But for the home buyers particularly, there is a second point which has been raised by the NCLAT, and they say that the plan should have dealt with this particular aspect also. So if your plan is silent, or supposing plan says that those people who have not filed the claim, they will not be entitled either for refund or for the flat. This was mentioned. So they said, sir, this is mentioned there. NCLAT says, this is no treatment. I'm asking for a treatment. You are squaring off their this thing. So now they were sent back that you please revise the plan. So today, what the real estate plans are, the resolution applicants are saying, typically, we have seen 2-3, and we have also advised them. They give a 1-year window. Some people give 6 months window. That those people who have not filed a claim, but they are the allottees, right? As per the data available with the RP, they are, if they file a claim within a period of 6 months or 1 year from the date of approval of the plan, then they will be given the flat, provided we will charge 500 rupees per square feet more, whatever. Treatment should be there. Whether you can give a harsh treatment to them, but some treatment should be there. So therefore, please make sure that while drafting of these kind of things, you examine from that particular angle also, that the interest of, because KV developer will have to take into account. And this is exactly what has happened in our case. And I'll take this argument a little further. In the meantime, I think Mr. Deep Kumar has raised his hand. Yes, sir.
Yes. Yeah. So I would just like to take forward your argument. So in this matter, what we presume that in IM, we should mention this, the claims which have not received and which as an RP we are aware, it should be form part of contingent liabilities in IM.
Well, I will not say right in a contingent liability, because contingent liabilities are different liabilities, right? Contingent liability is a liability which is dependent upon an event happening or not happening. I think most all chartered accountants here or maybe other professionals understand. All I'm saying is you can just simply mention that these are the liabilities as per the books of account. The total liabilities are.
So it is just like a not admitted or not claimed liability, right?
Not admitted or not filed the claim. Just be very clear. So provide an information available with you in the information memorandum. Let the other person take a call, what he wants to do with that. Okay.
Sir, I think for non-real estate CD also, we should also take care of all OC and FC, that these liabilities exist in the books of CD. They have not yet filed their claims, but their liability are still existing.
Absolutely. This is what I said. As far as the first part, it applies to all companies, not only real estate. But for the second part, that the treatment should be provided. So I will not say that you should provide treatment for other OCs who have not filed a claim. Naturally, you can say that their claims are haircut. There is 100% haircut for them. But for the home buyers, 100% haircut will not do. That's what I'm saying. That will not pass the test of KV developers.
Correct.
So one has to be careful on these kind of things.
Can I come up with, sir? Can I come up with a question, please?
Yeah, please go ahead, sir.
Yeah, so, see, in case the CD has been declared as a fraudulent account by the bank, can a related party come in, and CD is this is an MSME? Can a related party come up and present a resolution plan? Because though I'm not sure, but I think the word that have been used in 29 is a willful defaulter.
Yes,
you can please enlighten me on that.
Yeah, willful defaulter. So the process of willful defaulter has to be there. If willful defaulter he has not been declared, because that is 29A clause number B. It clearly says is a willful defaulter in accordance with the guidelines of RBI, right? Banking Regulation Act. So if they have been declared as a willful defaulter, only then. Just
my point is,
declaring the account as a fraud will not disqualify them.
Wonderful, because we are recently undergoing this sort of confusion where the CD has been declared as a fraud and related party has submitted resolution plan. We were in a quandary whether to consider it or not to consider it. But thank you very much for clarifying.
But sir, here there is one catch.
Yep.
Now taking a cue from IBPI writing to the department, isn't it? Right? You can also write to that bank where the loan, whether you have declared this person as a willful defaulter or not.
We preempted this, and we got a written sort of a stuff from the bank which says this guy is not classified as a willful defaulter but as a fraudulent party. So that much clarification is there.
Right. I think that's a safety which you are building.
That's wonderful. So that is the best part of attending your webinar. For a change, we listen and enjoy. Thank you very much.
Excuse me, sir, can we take 5 minutes break?
So
I
one
would love it to go on till.
अभी तो कोई time ही नहीं हुआ, sir.
Sir, let it flow, let it flow, let it
so
flow.
one thing I think, sir, is there any?
Sir, just hang on. We started at what time? 2 p.m. और कितने बजे start
Yeah,
किया?
2.
So let's take a break at 3:30. Just let's continue for 15
Fine.
minutes. Then
Sounds
we will
good.
take a break for 5 minutes. Okay, comfort
Sounds
break.
good.
Yeah. I know comfort break is required. Okay, I think there is Mr. Ranjan Dhingra.
So the
Rajiv Dhingra, sorry.
defaulter can be obtained from RBI side or?
नहीं सर, RBI तो देखिए, RBI कभी भी नहीं देगा. जो बैंकर्स हैं उनसे ले सकते हो. RBI तो रिस्पॉन्ड नहीं करेगा आपको. विलफुल डिफॉल्टर कौन डिक्लेयर करता है? RBI नहीं डिक्लेयर करता. दे आर डिक्लेयर्ड बाय द स्पेसिफिक बैंक, राइट? अब इसमें एक प्रॉब्लम और आती है. देखिए, let us extend that argument which one of our friends was just now mentioning, right? Mr. Gurbinder was mentioning. Now what happens is, a person is declared as a willful defaulter by the bank. This person, though the person who has been declared as a willful defaulter, he goes to the High Court and gets a stay. This is happening because everyone is going to the High Court, filing a writ and getting a stay. So what do? Whether you will treat it as a willful defaulter or not. Because at one point of time, naturally he was declared as a willful defaulter. And this is to be the position. Now, so therefore, my dear friends, the position is to be seen on the date of this submission of the plan. Here it is the submission of the plan. Here it is not on the date of ICD. As MSME status is on the date of the ICD. Now here, insofar as the eligibility is concerned, there are Supreme Court judgments. We are all aware. I don't have to go back. It is on the date of the submission of the plan. Again, ArcelorMittal judgment of Supreme Court. Date of submission of plan is the most sacrosanct, whether he was declared as that or not. So now supposing he was declared, but he obtained stay later. What will be the impact? Can we say that it is still under consideration? So these are the questions which are unanswered, my dear friends. But ultimately, if you bring all these things to the knowledge of the COC, this is our job. We are a facilitator. Let the COC decide then. So those kind of things can be done. Of course, I have to also submit my certificate of eligibility that yes, this person is eligible or not. So under a stay will definitely mean that for the time being, he is not a willful defaulter. Take a cue from the Supreme Court judgment, declaring disqualifying an MP. Later on, they say that we are putting a stay, he is restored as an MP. So therefore, he continues to be an MP, isn't it? So therefore, he continues to be eligible. I'll take that, you see, logic, extend that logic here also. So as far as that is concerned, if there is a stay, you can always say that he is not disqualified. But tomorrow, what happens if the stay is vacated and the order is upheld? Then what will happen? We don't know. That is going to create a problem. But that is going to create a problem not on you. It will be creating a problem at the time of, say, approval by the, supposing that judgment comes before the approval of the resolution plan. Naturally, now the adjudicating authority will take that into account. Then they will have to take a call whether to approve it or not approve it. They cannot approve it. So they will probably may ask the RP to again publish form number G, or they can send it to liquidation. We don't know what is going to happen. There are many options which are there. Okay, I think Mr. Rajiv Dhingra has asked some question in the chat box. Mr. Dhingra, if you are hearing us, can you just ask your question in person, or do you want us to read it? Okay. Okay, let's read it. It says, sir, what about a scenario where due to pendency of the OC, registry is pending, but possession handed over. Now for this, home buyer can raise their claim, but since the claim no form is filed, should that data be also captured? Okay, I think he is talking about the real estate, and here the OC does not mean operational creditor, probably it means the occupancy certificate, right? Because OC and CC are related concepts relating to real estate industry. I believe he's talking about that.
Yes, sir.
So,
Occupancy certificate only, sir.
yeah, occupancy certificate. Okay.
Only
Well,
this.
people are facing this problem not from today, from 2018 onwards. At that time, the law was not clear. We were giving a lot of opinions and all. Now, there are 2-3 questions which are related to this. Of course, it's not related to resolution plan, but I can answer it quickly. Number one, whether possession can also be given by the RP during the CIRP. That's a big question. Number two, if the CCOC is not there on record at the time of the CIRP, but certain people are already in possession. This is what his question is. That the flats have been given possession without the OC and CC to certain home buyers, and probably some are living, some may not be living also. Now the question, there are 2-3 questions. But here his question could be that whether these people claims will be considered, or can they file a claim? Now, supposing a person who has already taken a possession. Now, the big question is, can he file a claim?
Yes,
Now,
he can.
Okay.
Because he is not the title. The title deeds is not in his favor.
Achha, now tell me one more thing, sir. Let's say, I'm not saying anything you see right or wrong to your observation, but let's take this argument further. Supposing the plan is not approved in a real estate case, it goes into liquidation. And there are 100 home buyers who are living in that property. So what you will do? Will you sell their flats also? Will you ask them to vacate? Because you are saying that, look, they have not got registered, so therefore they are not the owner. So owner remains the company. So therefore the liquidator can sell those flats.
The answer is yes, but IBC is silent. IBC is silent, and they are not the registered owner as per the TP Act also. So ownership is still not transferred in favor of the home buyers. So the ownership is still vested with the CD. So CD can sell this property, but it is very difficult, or it doesn't happen in practical sense.
Sir, in some consumer courts, a small update which maybe you may like to throw some light upon. In consumer courts, the consumers, that is these home occupants, they were occupying the houses also for quite a few years. Now, since the value is not increasing, they went to court, got the decree in their favor. Now they are getting back the money also, interest also, and are saying, okay, keep the flat also with you. They bought at say 100 rupee. Now the flat is 50 rupee. They will be getting the interest for the period for which they have already used it. That's the order is there, sir, with me.
Right. So therefore, there can be a lot of practical difficulties. Let us try to sort it out one by one. This problem also came in few of our cases, and the RP asked a very pertinent question. He said, look, sir, some people have got a decree in their favor by going to the consumer court. Because a home buyer can go to the consumer forum also, and consumer forums very liberally pass those decrees after some time. So they say, okay, refund the money. Now they have got a decree in their favor. Naturally, if they have a decree in their favor, they are a claimant. But here the big question arises is, will RP consider them as home buyers? Because they went to the court, and I looked at a document, the application, they said, we do not want the flat, cancel that flat and refund our money. So when you have cancelled the flat, can you be categorized as an LOT? That's a big question. Because if you look at the definition of an LOT and you read it along with RERA, different provisions, can they be categorized as financial creditors? Because here comes the question. Financial creditors under 5.8F explanation are only the LOTs. So if you are no longer an LOT, despite the fact you have not got your money back, that's all right. But you book a flat and you are not given an allotment letter, or you are given an allotment letter, you say cancel this and give my money back, and in the meantime company comes into CRP, can you still be considered as an LOT? So therefore there can be different angles or different perspective could be there. So in that case, looking at the subject matter, we gave an opinion that such a person who has requested for cancellation himself will not be categorized as a financial creditor. Of course, he's a creditor. I'm not denying. He's a creditor. The money is to be paid back to them. But whether they should be categorized as a financial creditor or not, that's a big deal. And we argued this the same thing before the bench also. Number two, now coming to those who are already in possession. Now, point is, now some people can distinguish, there can be two arguments, whether possession is legal or possession is not legal. Because if CCOC is not there, is the builder, can rightfully, give the possession? The answer is no. If you read RERA, if you don't have CCOC, naturally no possession can be given. So therefore, it is not treated as a possession which is legal possession. They are living, their sympathy may be there. They are living for 3 years. They are enjoying electricity and every damn thing. And today, you see another thing, no CCOC, and there is a project in Agra where even registry has also been done. Can you believe this? The flat has also been registered by the builder in the name of the person concerned. So now the ownership has also got transferred to them. Naturally, they can't file a claim because the person who has become the owner, he doesn't have a claim. But CCOC is not there. Now, will you treat them as owners or not? Because they have got registry.
Yes, they will be treated as owner. Although they have violated the local laws, but
yeah. I mean, I don't know how it happened because it can't happen, but it is happening at many places. So these are all questions which will be there.
As you are telling
Yes.
now, once one person has given letter for cancellation, he will not be treated as financial creditor. Then which category he will be treated?
The other creditor. Other creditor, he is not even an OC. There is a classification, no? There is a third category also, isn't it, sir? There is a specific form which was brought out. I think you remember that old days.
Form F, sir.
When there was no form was there, then the IBBI amended and said for other creditor, this is the form. Yeah. Okay. I think there are two hands which are raised. One is Mr. Amrendra and one is Mr. Deep Kumar. Yes, sir. One by one, maybe you can.
Yeah. So my question is, let's say a situation where LOT, as per ATS, have paid the money to the builder, and they have received the OC and CC and they got a possession, but registry is pending.
Right.
Then what can be the option for the LOT in this scenario? To whom we should approach for registry, and whether there can be any claim?
That's a good question. Very good question. In fact, this same situation was faced by one of the RPs way back in 2019. And he asked for my opinion. I said, look, this person has paid the full amount. He is enjoying possession. Merely the registry is pending. Now, his question was, supposing I do a registration, will it violate section 14? Will it violate the moratorium? Because moratorium says no asset of the corporate debtor can be sold, transferred, alienated in any manner whatsoever. 14(1)(b). Now, that was his question. Then I said, look, this is an ordinary course of business. You are, the job of the company is to give flats. Possession is already with them. The registry is not there. But just to be on safe side, I told them, I said, ask that home buyer to move an application before NCLT. And he moved an application for registry, and the NCLT New Delhi bench, principal bench, I can share that order with you. He said that the RP shall register those people who have paid the full amount, and there are no other pending dues. And the flat is, of course, subject to the condition that OC, CC, everything is there. So all those things were there. Legally, everything was there. And we got a direction from the NCLT principal bench. So what opinion I gave him, but I suggested this is also a way out because this was the law which was developing. So we got an order for that. So registry, I don't think there is any problem. But having said that, the panel which was, created, which has submitted as a report on real estate. Now they have mentioned one paragraph. And they say that, look, during the CIRP, certain home buyers registry is required to be done. RPs cannot do it because of moratorium. So therefore, we must amend the law to permit the RPs to do it. So if I go by the interpretation of the panel which has submitted the report recently, it means that RP cannot register.
What is the meaning of going concern? If they cannot register, RP is not.
That's all right. That is there. So probably the company is not working. The projects are closed down. So probably they are thinking that is not a going concern for that matter. Anyhow, we are not going into debating into that. Therefore, please remember this. What I suggested to the RP, that ask that home buyer to move an application. Today, RP is safe. Once there is an order by the NCLT register, well, fine, I'm happy with it. So take as much as precautions as possible. Okay. Yes, Mr. Amrendra Kumar.
He seemed to be deviating and going more into real estate than resolution plan.
I know.
But when you talked about this consumer code, it is related to the resolution plan, because after I submitted the resolution plan,
right,
I had no knowledge. Somebody had been in 2011 or 2012 been promised a refund, had gone to consumer court, and came with a decree about 1 or 2 months back, saying that I should the CD should pay so much.
Right.
And then I wrote back to them telling me, look, you seem to have missed the bus. This was in CIRP from this date. The announcement was done on this date, and the resolution plan also has been submitted. And then their advocate called me and told me, I'm not able to find the claim form to submit our claim now. So I told him, look, my suggestion is, if you really want to put a claim, you have to go to NCLT, because I've already submitted the resolution plan.
Right.
That's the thing which I wanted to let you know.
Sir, these are very important cases, and forget about decree. There are other home buyers who did not file the claim. The plan is approved by COC, pending for adjudication, and then they come. In one of the cases, can you believe 90 applications are pending? 90. And some applications have been filed after the plan has also been approved by the NCLT. Now they are coming. So this is creating a problem. And there is a third set of people who have decrees in their hand, and they went to the NCLT saying that the plan is silent about our decrees. And because the resolution plan said we are going to pay them only 50%. So it was a kind of 50% haircut to them. And that too, payment in 3 years. They said we are getting in 3 years and only 50%. We are decree holders, and we should be given priority in payment. Do you know what the NCLT, one of the benches, did in our case? They said, yes, they should be given priority. And the resolution applicant should make the separate payment to them. After approving the plan, which talks about only 50% payment to them. Now, I don't know why these kind of orders are being passed. We have challenged, obviously, RA has challenged that order still pending. But anything and everything is possible in IBC today. But all I'm saying is, we have to proceed on a particular basis. See, friends, you can do any damn thing in CIRP based on your judgment. But protect yourself. What is the safety net? The safety net is the legal opinion. Take a legal opinion and work according to that, so that at least you are on the safe zone. Or maybe go through the NCLT route, let them get an order, and then once the NCLT orders, then obviously you can follow that. Okay. So I think last question we can take from Mr. Vimal Kumar before we take a small.
In the absence of registry, okay, NCLT application will be filed with NCLT. But in the absence of OC and CC, whether claim is to be filed with RP?
Sorry, sir, can you repeat your question again?
Possession is given by the builder. OC, CC is not done. Registry is not done. Claim should be filed with RP, or again application is to be filed with NCLT?
No. See, the point is, within the time period, naturally the claim will be filed with the RP only, right?
The possession is given, party is staying there.
Achha, possession has been given to them.
OCCC is not done, registry is not done.
Okay. So in that case, naturally it will come to the RP, and RP will make a note saying that this is the claim he is admitting, but there is a possession which has been given, but this possession according to him is not legal. So just whenever you are admitting such claim, put an asterisk and then give a note at the time.
Amount will not be there for that claim.
जितने disclaimer डाल सकते हो, note डाल सकते हो, डाल दो.
So that one question.
Yeah.
Is the OC a secured operational creditor? Is the decree holder a secured operational creditor or operational creditor only?
Mr. Ranjan, the answer to both the question is no. Merely because somebody has a decree does not mean he become a secured creditor. Secured creditor he will become only if he has a security interest, section 331 and 330. Please read these two sections. What is the definition of a secured creditor? He must hold a security interest, and decree is not a security interest. So therefore he is not.
So
And
in that case, voting right will not be given to that person, no? Who has
फाइनेंशियल क्रेडिटर नहीं सर, फाइनेंशियल क्रेडिटर है तो वोटिंग राइट होगा, सिक्योर्ड क्रेडिटर और नॉन सिक्योर्ड से वोटिंग राइट तो इम्पैक्ट नहीं होता ना सीआईआर।
नहीं ओसीसीसी की बात कर रहा हूँ, वो क्लेम फाइल कर दिया पोजीशन मिलने के लिए।
ओसी में नेचुरली इफ यू आर ट्रीटिंग, सी फाइनेंशियल, सो होम बायर्स आर नॉट ओसीज, होम बायर्स आर आइदर फाइनेंशियल क्रेडिटर्स और अदर क्रेडिटर्स।
So sir,
नहीं sir, confused. You are confused. What I am telling, in case OCCC is given, not taken, but possession is given. Claim is submitted to RP. RP is mentioning disclaimer, but whether that person will get voting right or not.
See, naturally, if you are admitting a claim, the voting right is
Yes.
that voting right. So therefore, voting right is to be given. No doubt about it.
sir, 53
You
में
cannot deny a voting right.
सर 53 में डिक्री होल्डर कहाँ पे आएगा?
सर डिक्री होल्डर का देखिए, clearly they are considered not as an allotee. If you go very technically, look at RERA provisions and look at all the scheme of the RERA, they are not considered as allottees. Once they have cancelled a flat, please let us look at this. I booked a flat, I was given an allotment letter, that is why I'm an allotee. I asked for cancellation of the allotment letter. Can you still consider me as an allotee? So now money is lying with the corporate debtor, that's fine. But that is like a loan, that's all. Or that is
when the flat is not cancelled, in that position, what will be the status?
When the allotment is cancelled, the flat is cancelled, no?
No, sir. When the allotment is not cancelled, either by the builder or by the.
So therefore, we will go by the word allotee. So please look at it, because you see, I cannot answer very specific questions without looking at the facts of the case, right? So all I'm trying to say is, look at the scheme of the RERA, because the definition of allotee is borrowed from RERA only. So please see whether the person is still considered as an allotee or not. If the person is considered as an allotee, naturally, then he is a financial creditor. If it is not, then it will not be. So depending upon those facts can change. You will have to take a legal opinion on this particular aspect. All right.
Refer section clauses D and ZN of section 2 of RERA.
Yes. Definitely real estate project and allottees are defined in RERA Act only. Okay, friends, I think let's not extend this further, because we will actually digressing towards real estate. Let's take a 5-minute break. My watch says 3:37. Let's meet at 3:42. Is that all right?
Done.
Great. Okay, sir. See you in 5 minutes. Okay, friends, welcome back. So I think please come back so that we can start the proceedings now once again. Okay, yeah. So I think we had a great discussion on real estate and other things that, of course, you see is very hot topic as of today. But let's come back to the resolution plan, because that is extremely important. Like what we have been the topic of the day. I think that's very, very important. Okay, can I request everyone to just please open your videos if it is possible? Yeah, because yeah, that's wonderful. Yes. Okay, so let's look at now. There are 2-3 very important aspects which I would like to bring to your notice, because there are many judgments which have come, and naturally we need to discuss that what are the implications of those. So having discussed all these points, now let us talk about the examination by the RP under section 30 subsection 2. Now that is very, very important section. 30 subsection 2 is a very crucial section, because most of the you can say objections to the resolution plan, they come under this particular thing. Now, what does it say? Now, it simply says that, look, as far as the resolution plan is concerned, RP has the duty to verify or examine. In fact, the word is examine. The RP has to examine the resolution plan which is received, and then he has to confirm. Now, confirmation is very important, right? So A also talks about that it provides for the payment of the CIRP cost. That is fine. I mean, naturally, we'll have to do that, and that too in priority of the other debts. The clause number B is extremely crucial, friends. And in fact, I'll go to F also, which is also very important. Provides for payments of the debts of the operational creditors in such manner as may be specified by the board. That means the amount to be paid to the creditor in the event of liquidation of the corporate debtor, and the amount that would have been paid to the creditors if the amount is distributed in order of priority under section 53(1). So here, the operational creditors, my dear friends, we all are aware that they have been given some kind of a minimum guarantee. Now, this exercise RP must do. Please prepare an Excel sheet. I've got a template of that Excel sheet. If you want, I can share it with all of you. Maybe I can share it with ICICI and they can send it to you, because I may not be having the email IDs of everyone. So this is one template which you must prepare. What is the liquidation value, what is the resolution plan value, and how much they are getting. So 3 things you have to compare. What they are getting under a resolution plan. Now this needs to be compared with that if the resolution plan value is distributed in accordance with 53, what they would have got. Third, what is the what they were expecting to get in the liquidation if it is distributed in accordance with 53. So liquidation value distribution, resolution plan value distribution in accordance with 53, and what they are actually getting, 3 values have to be compared, and they will get the maximum of that. But generally speaking, if you ask me, I've seen many of the cases where OCs generally don't get anything, right? Typically, they don't get anything, but then we must do that exercise to convince the NCLT benches later on. And they generally ask for this because
some
objections
exception is there, like GST Department of Gujarat, GVIT Gujarat. They are treated as secured creditor because of default made by the CD in payment of sale tax or GST, and the lien has been created by operation of law in favor of the GST department.
Mr. Jan, I think you are talking about Rainbow. Let's not bring Rainbow, because I'll tell you, there has been a judgment after that which has cleared the way, because they say Rainbow has been passed in the facts and circumstances of that case. So that particular thing will not apply here. So therefore, I will not treat that. It was under a different circumstance. Rainbow was given under different facts and circumstances. So therefore, the same thing may not apply here, right? So that's, and
Sir, I am talking for the same facts. If same facts exist, then.
Well, you see, that's what I'm saying. There are grave doubts on that also, because that judgment is not, with due respects to the Supreme Court, it is not a good judgment. So therefore, there is a later judgment where they have distinguished from rainbow also, same facts, same set of facts, where there was a first charge over the assets of the corporate debtor. They are still saying you are treated as the government dues are treated as operational creditors only. They cannot be made at par with the secured financial creditor. So there is a different judgment, differing judgment with the same level of the bench. So therefore, let's not talk about it, because that judgment has been challenged in another judgment. So let's wait for that. But I'm 100% sure that rainbow will be overturned, or the impact of that rainbow will be overturned, because that's not the implication. In the later judgment, the Supreme Court says government dues are considered as operational creditors, and operational creditors fall at level number 5 under 53. They may be secured. If they say secured or unsecured, we don't care. So therefore, your priority will not be in accordance with 53(1)(b). So that is there. So anyway, I don't want to go into that dispute right now. So anyhow, this is one. The second is, as far as the dissenting, in fact, the word dissenting is also not there. If you look at section 32B, after 1 and 2, subclauses 1 and 2, there is a sentence, right? And provides for payment of debts of the financial creditors, and underline the next word, friends, who do not vote in favor of the resolution plan. We always read it as dissenting. They are not dissenting, right? They have voted against, because dissenting can also include those who have not voted. Because earlier, the definition of dissenting in the regulation was the people who do not vote or who vote against are treated as dissenting. So dissenting is a different terminology altogether. So we will have to consider, supposing now, let me give you an example. Supposing there are 3 financial creditors are here. One has got 80%, another has got 10% voting share, another has got 10%, 80, 10, 10. Now 80% approves the plan. Second financial creditor holding 10% votes against. Third financial creditor holding 10% does not vote. Will the benefit of 32 be given to the third creditor? The answer is no. The answer is no. Because here the benefit is given to the person who have voted against the resolution plan. It doesn't say dissenting. So therefore, please read the words very carefully, right?
Absent person will not be counted here.
Absent or not voted, right?
Abstain, yeah, not voted.
Abstained, yes, abstained.
Abstain.
Abstain, not absent, abstained, yes.
Abstain, yeah.
Right. So those who do not vote,
in that case, 90% will be treated as 100%. Out of that, voting will be decided, correct?
Naturally, 90% will be treated as 100% base, and out of that, 80 divided by 90 will be treated as the percentage pass. Naturally, that is the style which we do it, right? Okay. So the whole point is that what is the benefit which is given to them? Now there is a small, you can say, a problem in it. When a plan is submitted by the resolution applicant, does he know who is going to vote against? He does not know, because this will be known only when the voting is done. So in the resolution plan, how it should be drafted? Now that's a question. It's a very important question. Typically, you must see as an RP that there is a clause which simply says in general terms that if any financial creditor who votes against the plan will be given the amount, will be given, we are providing for the payment not less than as per section 32B(1) and 2. You can reproduce that line straight away. Because you don't know who is going to vote against. I can't provide the quantum. Now, the same situation happened in one of our cases. HDFC Bank, which had a very small percentage because of they had charge over the vehicle. So they had given only vehicle loans, which are very nominal loans, right? 50 lakhs against 100 crores. So their voting percentage was 0.03%. Now they voted against. And when they voted against, and they filed an application that we should be provided in accordance with 32B(1) and 2. When I was appearing for the RP, I said, my lord, yes, we will provide. Then the lawyer of then the counsel of that person said, sir, their plan does not disclose the value, how much I'll get it. I said, my learned friend is putting the cart before the horse. I never knew whether they are going to vote against or not. How can a resolution plan provide for the value? So today, now we know that they have not voted. So now I know what is the value. So whatever the value is, that will be paid. So bench naturally then typically maintain a balance and equity. They said, Mr. Makhija, can you disclose what is the amount you are going to pay to them? I said, now I can disclose. There's no problem. So I submitted a chart in accordance with 32B. I said, look, they are entitled for this. So bench was satisfied. They said, now you are satisfied. What is the problem? So all I'm saying is, some people generally say that, look, you have to disclose the amount. You can't, because you don't know who is going to vote against. So this is extremely important, friends, that you should provide for this. Your plans must be examined, that they must contain this clause, right? As far as OCs are concerned, it is not dependent upon voting. So naturally that clause has to be there. But for financial creditors who do not vote, you have to keep a general clause in accordance with 32B. And this is your duty to check it also. Because if you don't check it tomorrow, you will be the scapegoat, not the RA. So therefore, it is extremely important that you must do this. Okay. And this is a very important section.
Sir,
Then
excuse me,
yes,
sorry
sir.
to interrupt. I have a small doubt.
Yes, sir.
The government departments, what they normally do is they service a demand notice on a company, and they go to the sub-registrar office and create a charge on their assets. Okay, so that the asset doesn't get transferred to the transferee when the sale happens. So if that particular the company comes for a CARP and the order is passed, and already the bank has got a charge on those assets also, what will happen in this scenario?
Okay. So
that the bank will whether
okay,
the bank will
just give me, just give me a moment. There is a judgment on this. I'm just trying to tell you that judgment. I'll tell you the answer first, and then I'll give you the judgment also.
Yeah, please.
The answer is very simple, that you are probably talking about liquidation, because sale happens in only liquidation.
It is not necessarily liquidated. Even in CRB process also, suppose if I want to give the asset to the buyer, the applicant, how will I pass on to him? Because when there is the existing demand from the income tax department, because you told income tax department or even GST department for that matter, you told that they come on only as an operating creditor. Okay, so they come on the 5th rank. So in which case, whether the financial creditors will continue to have the same holding, or they have to give away for the department.
No, sir. I'm trying to understand certain things from you. Number one, in CIRP, the amount which will be paid in accordance with the plan.
Yeah, I agree.
Right. So whether government department or any other financial creditor, if they approve the plan and the plan says, because I was going to the contents of the plan also, one of the regulation clearly says that it can change the security interest, it can alter the security interest, it can do any damn thing, right? Whatever way you want, you can draft your resolution plan. There is no restriction. Once it is planned, then everyone is bound by it, whether it's a government department or a non-government department. So therefore, I'm not clear with your question. Where is the question of?
I'll clarify my question again. If you are not very clear about the question, I'll clarify. You can even take a liquidation also. Not a problem. You take liquidation. Right. When it goes to liquidation, what is the status of the charge created by the government department on the fixed assets of the company?
Okay, now let me answer that. There is a judgment. I was just trying to look at that. I'm just forgetting the name, because that was a very
no problem.
So I'll give it to that, because I was trying to find out in my book, but probably some other edition is not there. But anyway, you can give me your email ID. I'll share it with you. Now the answer is this: at the time of the liquidation, the proceedings are to be distributed in accordance with Section 53. Clear, sir?
Yeah, that is clear.
In that case, what had happened? The property was sold to a person, to a buyer. The buyer purchased it. They went to the sub-registrar for registration. sub-registrar refused registration because they say there is an attachment by an income tax department.
Exactly.
Exactly the same thing.
Exactly same.
So there is a judgment of, I believe, the High Court, and the High Court clearly mentioned in that particular case that, look, this attachment is invalid. It needs to be deattached, and they directed the sub-registrar to register it. And then the question came, how the government dues will be paid. They said, you file a claim and you remain in the queue. You fall under 53(1). Yes, 115. So you will be paid in 1E. You will be paid in accordance with that. So that attachment or no attachment, that has to be deattached. So please remember, friends, the latest judgment after Rainbow is government dues, whether they have first charge, whether they have any charge, there is no quarrel that they are secured creditors. But they are not secured financial credit. In fact, there is a confusion, right? If you read 53(1)(b) and read 53(1)(e), there is a confusion because 53(1)(b) clearly says secured creditor. It does not say secured financial creditor. And the clause where the government dues are said, they simply say government dues. It doesn't say whether secured or unsecured. I think we debated this, you see, whole issue after Rainbow, number of webinars, and I suggested that the government can amend the law. Either in the 53(1)(a), they can say secured financial creditor so that it sets at rest, or in the clause number 5, they can say government dues secured or unsecured. So the whole thing will settle down. Having not said, there is that latest judgment of the Supreme Court has clearly clarified, my dear friends, that despite the fact that there is a first charge, they will be treated as operational creditors only. So even if they are secured, they will fall under the fifth limb. Yes, sir.
I was just telling, sir, the same problem arises in this CRP also. CRP says only OC or FC. That's it. Nothing more, nothing less. But here, the NCLT has directed to RP to treat him as a secured credit.
No, Ajay, see, we are all clear that insofar as CRP is concerned, secured and unsecured, as far as COC is concerned, there is no difference. But when you apply 32B, then you will obviously see who is secured, who is unsecured, and who is operational. That differentiation comes only at that point of time, not before. So my friends should be aware, when you are applying 53 to read with section 32B, then you will have to see who is secured, who is unsecured. Otherwise, you will not be able to do it, right? That's what I'm trying to say. Okay, yes, Rajkumarji. Sorry, you could not speak earlier. Yes, sir.
In one of the discussion paper, to amend the section 53 with regard to the government dues, they want to add the clarification or explanation that they will continue to be treated as unsecured. In one of the discussion, it was there.
Okay. Maybe I'm not aware of such discussion paper. Maybe, I don't know, I might have missed that.
Few months back.
Yes, because you know that, sir, when we were debating Rainbow, isn't it? आपको याद होगा सर, हमने कितना डिस्कस किया, 3 घंटे का सेमिनार किया, and at the end of every seminar I mentioned that these 2 changes are required. Either you do at the top, you say secured. So today I'm very happy that what I was suggesting, the Supreme Court has also said the same thing. They said secured creditor in 53(1)(b) should be read as secured financial creditor. They have not minced their words. They said, yes, it should be read as secured financial creditor. Why? Go to the preamble. Somebody argued the preamble, which we were also arguing. I'm very happy about that. In the preamble, it is mentioned alteration in the order of priority of the government dues. So from Companies Act, winding up provision, there is an alteration. Earlier, government dues were treated as preferential creditors. They have been brought down at a different level, lower level now. So the Supreme Court says the intention of the legislature is absolutely clear. Despite the fact they are secured, they cannot be compared or become equivalent to secured financial creditors. So they will fall under the 5th limb only. So therefore, friends, this is very important. Okay. So please read the new judgment. That's very, very important. Okay. Yes. Sir, as a layman, can I be clarified whether a person be a financial creditor and at the same time he be an operational creditor? Okay. Mr. Hans, Probably I've not understood your question. What you're saying is you don't understand the meaning of the financial creditor and the operational creditor. Is that the question?
No, he wants to know, I think, whether he can be both a financial creditor as well as a operating creditor. That is what I'm
Yes,
able to
sir.
understand.
Yes, sir. A single person can also be treated as an operational, and depending upon the agreement. Supposing I have given a loan to the corporate debtor, I'll be treated as a financial creditor, but I'm also supplying material which has not been paid. I will also be categorized as an operational creditor for that amount. So I will enjoy two hats. I can wear two hats. So there is no problem, sir.
Can I club this? But to determine the threshold limit of 1 crore.
No. You cannot club it, sir.
The law is given. The provisions are clear.
Provisions are clear. Read section 7 and section 9. I'll just give briefly. Section 7 says financial creditors can file the application jointly or singly. So clubbing of financial creditor dues can be done, but this word jointly is missing in section 9. So therefore, the dues of the OCs or the dues of the FC and OCs cannot be clubbed. Okay. I think we are all clear on this. Okay. Yes. Let's go further. Okay. So after this 32B, friends, C, D are you see are very nominal, right? Whether it should provide for the management of the corporate debtor, it should provide for the implementation. Of course, you must make sure. Please read it very carefully. This is your job. What I'm seeing, what the trend I'm seeing, my dear friends, is you appoint a process advisor. Generally, I mean, in a large cases, process advisor is appointed. He verifies 29A. He verifies whether the plan is in accordance with section 32 clauses or not. And based on that report, you just submit your certificate. That's all right, my dear friends. You guys are completely competent. Regardless of the fact whether you have appointed the process advisor or not, you must verify it independently. क्योंकि जो आपकी नजर से निकलेगा ना, वो process advisor भी शायद miss कर सकता है. So please remember this, that you have to really apply your mind to this. So don't really believe blindly on any report or any certificate, because tomorrow the liability is yours. Read section 32. Verify and confirm. Who is the scapegoat? RP. So let's do it with an eagle's eye. We must scan these plans. Now, last two, my dear friends, are very typical. Last two clauses. Does not contravene any of the provisions of the law for the time being enforced. My God. Look at this. Everything under the sun. Can anybody tell me how many laws are there in India? Go to niccode.in, right? indiacode.nic.in. That's the website where all the laws of India are listed. More than 1,000 laws, 1,500 laws are there. Maybe more than that. I don't know. I may be wrong. So is it possible? And then there are state laws. And this is one of the problem which came. Let me give you that one practical aspect. Again, I'm coming back to the real estate because the plan was approved in that particular case. And didn't I tell you that we got approved 2 plans which were set aside by NCLAT? NCLAT set aside on a different reason. Now I'm bringing the another problem to it. The argument, the application was filed by Noida authorities. What did the plan say? The plan mentioned, and in Noida, let's try to understand, the land is given on a lease, right, to a company. That company enters into a joint development agreement with the corporate debtor. So corporate debtor is not the lessee. Corporate debtor does not own the land because the ownership is still with Noida. They are the lessors. Lessee is X Limited. X Limited has entered into a joint development agreement with the corporate debtor, and corporate debtor, based on that, is building the flats, and almost 80% were complete. In the resolution plan, there was a clause which was put in by the resolution applicant, saying that the land, the ownership of the land shall stand transferred to the corporate debtor. I mean, not ownership, they will become the lessee, right? Right now, they were only under the joint development agreement. They said, we will become the primary lessee and not X Limited. And this plan was approved. Went to the NCLAT. And Noida authority said, number one, sir, we are, their single line of argument was, we are the owners of this land. How can you include that land in your plan without giving us the notice?
Correct. The privity of contract is lacking with the CD. That's it. Nothing more, nothing less.
Now, obviously, arguments were taken because it was not that easy. In the joint development agreement, that was also filed with Noida. So Noida knew that who am I? Because
merely, sir, knowledge doesn't mean that privity exists. Privity must be in writing.
So therefore, and in any case, sir, there was another agreement that which was, you can say, a tripartite agreement in which Noida was also a party. Anyhow, I'm not going into that, you see, more details of the case because facts naturally change. I don't want to argue on that because the matter is now before the Supreme Court, and Supreme Court has given a stay on the unclad judgment. But anyway, all I'm trying to say is that this was a clause which was mentioned in resolution plan. Friends, let's not do it. Because it can create problems. Whether we win that case or not in Supreme Court, that's a different matter. On the basis of emotions, because there are, you see, 4,000 home buyers are there, that's a different issue altogether. Supreme Court may permit, because now the home buyers say, okay, we are ready to pay the dues of Noida authorities and all those aspects. That's a different issue. Some settlement may go on and the problem may be sorted out. But all I'm saying is, if a plan says this kind of a thing, that a leasehold property, you will become the main lessee or you will become the owner and you do not notify the opposite side, then it is a problem. If your plan says so, you must insist the bench to issue notice to that particular authority. In another case, similar type of case, because in Noida, Greater Noida, the same things are happening. So therefore, in the similar case, what we have done is, the clause is different, where they're saying that we will pay the entire dues of the Noida authorities, and they are requesting that from our subsidiary, the land should be now transferred as a lease to us. But here, the plan says so. We have given a notice to the Noida authorities to come and make their submission, so that tomorrow it should not happen that the plan is approved in their absence and then we are in trouble and then again the plan is set aside. So all I'm saying is, please be careful. What I'm trying to point out one more thing. The council for the Noida authorities quoted a state government law because they say, as per this law, Noida is the owner and remains the owner. Now, all I'm saying is that we need to know the local laws also, because here it says, and the argument was that RP did not consider this law. Imagine. So therefore, my dear friends, it is extremely important that you look at the local state laws also, because they may say something other than the central laws. So this is also very, very important, right? And of course, the last one says confirms to such other requirements as may be specified. Those things have to be done. Now, friends, one of the important aspects which was added in section 30, because the problem was relating to the feasibility, viability and feasibility, and the manner of distribution. Now, there were two aspects which were missing. Let us take examples first. Feasibility and viability, it is the duty of the COC. It's a part of the commercial wisdom, and there are not one, there are hundreds of judgments we talk about this now. So I don't have to repeat that. That commercial wisdom is supreme. NCLAT, and it is non-justiciable. NCLT and NCLAT cannot enter into that domain at all. They can look whether the process has been complied legally or not, but they cannot go into the commercial viability. And the plans can also be approved lower than the liquidation value. We remember that judgment, Maharashtra Seamless, very old judgment of Supreme Court. But there was one problem which was there. We know that every RP files, you see, avoidance applications, and certain recovery is expected. Now, who gets a right to get that recovery amount? Now that's a big question. And I, for one, since beginning, I advised RPs to please include this in the resolution plan, but most of the plans were silent. And everyone was believing that, look, an application has been filed for avoidance application by the corporate debtor, naturally by the RP on behalf of the CD only. So if any money comes, it will come to the coffers of the CD. And CD will use it. But if the plan is approved, in fact, RA is using it because now RA is the owner of that company, isn't it? Of course, it belongs to CD, but who has become the new owner? The RA. So there was a confusion where we saw a lot of differing judgments which are coming from Delhi High Court, and there is a division bench judgment also, which has also stated certain things. So thereafter, my dear friends, the looking at the problem, the IBBI amended, I mean not IBBI, the government actually kind of amended the law. And now you will find that in section 30, subsection 4, which is a very important section. Mr. Ajay, can you just read 34 for the benefit of the participants?
Yes, sir.
Just for a moment.
Section 30, subsection 4 says the COC may approve a resolution plan by a vote of not less than 66% of voting shares of the financial creditors after considering its feasibility and viability, the manner of distribution proposed, which may take into account the order of priority amongst creditors as laid down in subsection 1 of section 53, including the priority and value of the security interest of a secured creditor and such other requirements as may be specified by the board.
Right. So there are two things which I want to emphasize, friends, amongst all. Feasibility and viability, I think we have all debated too much. I don't want to go into that. The next one is important.
Yeah,
the
provided that
salary. Provided that is talking about you say transitory cases, right? Transition cases were there. Okay. So manner of distribution, you see how the money is going to be distributed. Number one, the first question is, the resolution applicant says, I'm going to pay you 50 crores. How much financial creditors get? How much unsecured financial creditors get? How much operational creditors get? How much workman and everyone gets it? Who is to decide? So now the power is with the COC. The COC will decide the manner of distribution. While arriving at that decision, the law very clearly says that they may take into it. The word is may. But I will read this may as shall, but they may take into account the order of priority and value of security interest of secured creditor. Now that is also very important. So priority is that if you are distributing the money, naturally you will see who are the secured creditors, who are unsecured, who are operational, and therefore you may take into that account. That's fine. That's one part of it. And of course, you must make sure that operational creditors get minimum amount as mentioned in 32B. That is also to be seen, to be read along with this. But the question that arises is, my dear friends, and there is a recent judgment also, there's a very important thing of Delhi High Court, and not in IBC, but is in winding up cases. So that's a very interesting judgment. I'll mention that. Now, priority, and this another word which is written is value of the security interest of a secured creditor. Now, here comes the question. Let me give you an example. I mentioned to you that HDFC Bank had given a vehicle loan. Supposing Bank A has given a loan of 50 lakhs for vehicles. Naturally, the value of the vehicles goes down. Say after 5 years, the value of the security interest is only 5 lakh rupees. And their claim is say around 30 lakhs, right? So 30 lakhs remained unpaid, but the value of the vehicles today is 5 lakh rupees. But they are secured creditors, mind you. They are secured creditors as per 53. And there is another bank, Bank B, which has given 100 crore loan. And they have a security over land, building, plant, machinery, every other asset except vehicles. And the value of the assets will be, say, more than 70 crore or 80 crore. Now, the question that arises is, now Bank A and Bank B are both secured creditors. can a differentiation be made in the resolution plan that bank A will get the amount only equivalent to the security interest because their value is only 5 lakhs. So plan can say, I'll pay you only 5 lakhs. Maximum chunk of money will go to bank B, and then of course it will be distributed to the government dues and so whatever, smaller portion. Can the resolution plan say so? The answer is yes, because the law also provides it. May take into account the order of priority, the manner of distribution and the order of priority, including the priority and value of the security interest. So value of security interest is also important. The second question linked to this. Some bank has got a first charge, another has got second charge. Both are secured. How much you will propose? Will both of them, will they be treated as the same class of creditors? Because secured creditor is one class. But can you distinguish between secured creditor itself? Law is not clear because even in liquidation, there was a confusion. If somebody has a second charge, let us go and read 53. Sir, can you just open 53 for a moment? Because that is also very relevant out here. And I'll tell you there is a Delhi High Court judgment on this now.
Section 53. Section 53 says distribution of assets. Distribution of assets, subsection 1, notwithstanding anything to the contrary contained in any other law enacted by the Parliament or state legislature. For the timing in force, the proceeds from the sale of liquidation assets shall be distributed in the following order of priority and within such period and in such manner as may be specified. Namely, A, the insolvency resolution process cost, that is CRP cost and the liquidation cost, paid in full. B, the following debts which shall rank equally between and among the following. Roman 1, workmen's dues for the period of 24 months preceding the liquidation commencement date, and number 2, Roman, debts owed to a secured creditors in the event such secured creditor has relinquished security in the manner set out in section 52. C.
So, just hang on there.
Yeah.
So, sir, in clause B, obviously the pro rata to the workman dues for 24 months had to be paid pro rata to the secured creditor. So, word here used is secured creditor. Does it say first charge holder or second charge holder? The answer is no.
No distinguish.
And let's go to explanation, sir. Aap explanation padhiye, sir, jo first wali hai.
Yes, sir. For the purpose of this section, it is hereby clarified that at each stage of distribution of proceeds in respect of a class of recipient that rank equally, each of the debts will either be paid in full or will be paid in equal proportion within the same class of recipient if the proceeds are insufficient to meet the debts in full, and the term workman dues.
Just hang on. No, second is not important for here. So all I'm saying is they are talking about a class of recipients that rank equally.
So equal must be treated equally. Yes.
So here in that, if we go to 53(1)(b), the class is only secured creditor. Then there is no differentiation. There is no difference. Of course, now there is a judgment which says the government dues will not be secured creditor in 53(1)(b), but they will be considered as 53(1)(e). That's a separate issue altogether. But we are talking about the financial creditors. Somebody has got, now here another question. Somebody has got security interest of only 5 lakh of rupees. The other bank has got security interest of say 100 crore of rupees. And third is the situation where there is a second charge holder. Now, as for the second charge holder, let me deal with that because there was a confusion. And nobody was clear whether the inter se agreement between the two financial creditors, inter se means who is the first charge holder, who is the second charge holder, whether that should be recognized or not. I, for one, has maintained in my book also and every time that this should be respected. The first charge holder should naturally be preferred than the second charge holder. Because I'll give you one more example where I'm coming from. Let's take section 52. Supposing the secured financial creditor who has got a first charge does not relinquish security interest. Naturally, they have got a right to sell the property and recover their money. They will not pay zero amount to the second charge holder if no money is left. So if that is the formula, then why can't we apply that formula in 53? So there were two committee reports are there. This issue was brought to them and it was requested that please amend the law. The committees in both the reports said there is no need to amend the law because the law is clear on this. That second charge, that the inter se agreements should be recognized. This is what they have said. Now, fortunately for us, my dear friends, of course, not in IBC, but in winding up provisions, 2023 judgment has come recently. Last month, Delhi High Court has given a judgment. Let me give you some facts so that you understand. The distribution, the money with the liquidator, official liquidator was less. Naturally, obviously, money is always less than the claims. Then the claims of the secured creditors were there, first charge holder, say, assuming 50 crores. I'm taking an example, 50 crores. Workman dues were also there, say 1 crore. And there was a second charge holder dues, say 20 crores. So total 71 crores. Now the distribution which was to be done in pro rata manner, the liquidator applied, supposing only say 10 crores is available. So how this 10 crore will be divided amongst the workmen and the secured creditors? They divided a ratio of 50:1, 50 for the first charge holder and 1 crore for the workman dues. So they divided 10 crores by 51, multiplied by 50 goes to secured creditor, multiplied by 1 goes to the workman dues. The second charge holder went to Delhi High Court, filed an application. They say pro rata distribution should not be done by taking the denominator as 51, but it should be taken as 71. Because we are also secured creditor. So distribution should be done like this. Delhi High Court, looking at the scheme of the Companies Act, which is quite similar to, because this distribution waterfall mechanism is absolutely borrowed from the Companies Act. There is no difference except the unsecured financial creditors have been given a priority than the government dues. That's the only change. The Delhi High Court says, looking at the scheme of the things, and they have gone into greater detail, they say, look, if there is an agreement that there is a second charge holder, there is a first charge holder, and when it is a distribution comes, we will take the denominator as 51 only. We will not take as 71 if the money is not sufficient. The reason is they say you are not entitled. If I take 71 as a denominator, that means you are also entitled for some money, which is not the case here. So therefore, it is absolutely clarified, my dear friends, by Delhi High Court, and I'm very happy with that judgment. I'll you see, write that judgment name in the chat box in a little while. But this is the latest judgment, and it clarifies. I mean, if you read it, you will be your concept will be clear that second charge holder is not entitled at the time when the first charge holder is being paid. So this is a fantastic judgment, which can be, because the principle of that judgment can also be applied to IBC. That's a very good judgment. Okay, so this is what I think we wanted to do this. Achha, now there is one more aspect. Before you see, any questions, sir?
Yeah. Can I have a clarification on the last?
Sir, we can't, your voice is too low, sir. I can't hear you.
Okay.
Can you increase your volume or?
Just a moment, please.
Anyone is able to hear our friend?
No.
I think he was internally discussing and he was unmuted.
Acha, okay. Okay. That's fine. So multitasking. Okay. So let us look at one more aspect. Okay. Let's see if there are any questions which are there.
Sir, if the first charge holder relinquishes security interest, but the second charge holder does not relinquish security interest in a liquidation process, how this is to be tackled?
Well, I would say that the second charge holders, you see, charge is subsumed in the first charge holder. So if first charge holder relinquishes it, so naturally, you see, whatever money comes, their money, they will be paid first. If anything is left out, then the second charge will hold. So I do not believe that second charge holder has to specifically relinquish. If they relinquish, very good. But if they do not, I will still presume it subsumes, because there is no judgment right now. This is only a matter of opinion, but definitely the judgment will also be like this. Okay.
Okay.
The second charge holder will be subsumed in the first charge holder. So he can't have a different opinion at this stage. Okay. Right. Okay. So one more, three more aspects. Before I leave it for discussions or any questions, we will take it at the end also. One of the important aspects, when we are discussing the negotiation and drafting, before we do that, I think there is one more aspect which I wanted to mention. Just give me a moment. I may show you a presentation which has some kind of this thing. Okay, let me share my presentation. This was made for some other purposes, but I think I can share it with you here. Okay, so I believe now you can see this, right? Let me increase the size. Okay, so this was, we were talking about 25(2)(I) and 33. Which one should prevail over the other? I think we have already discussed. This was a judgment, ArcelorMittal and Satish Kumar Gupta. And this is what the Supreme Court has said. And I would like to read this. Section 33 must be read in conjunction with 25(2)(I) and proviso to section 30 subsection 4. The resolution professional is not required to take any decision, but merely to ensure that the resolution plans submitted are complete in all respects before they are placed before the committee of creditors, who may or may not approve it. Section 32E does not empower the resolution professional to decide whether the resolution plan does or does not contravene the provision of law. Look at the language. He says it does not empower the RP. Ultimate, they say the decision lies with the, creditors, the committee of creditors, right? So these are the things which are there. And of course, commercial wisdom, this is there. I just want to show you something here. This is also very important. Yes, this is what I wanted to discuss. Well, friends, I think you are aware of that judgment also, but the question relates to is whether the RA is entitled to attend the meeting of the COC where his plan is being discussed. Well, the answer is yes. The answer is given in section 30 subsection 5. Yes, sir. Can you read section 30 subsection 5, Mr. Jan? Just read it very quickly. Yeah, just read it quickly for the benefit.
The resolution applicant may attend the meeting of the COC in which resolution plan of the applicant is considered, provided that resolution applicant shall not have any right to vote at the meeting of the COC unless such resolution applicant is also a financial creditor.
Right.
Here it says may, he may attend.
So then he has got a right, na?
Yeah.
So point is, he may attend, he may not attend, that is left on him. But the question which arises is the RP duty bound to send a notice of that meeting? The answer is yes.
Yes.
He is entitled. So here, what has happened in one of the cases, and typically what was happening earlier, I try to understand. In early, 2018-19, what was happening? And that was relating to suspended directors. I'm talking about that also. Suspended directors were not given the full agenda papers. They were not sharing. No RP was sharing initially. Despite the fact that they given a confidentiality undertaking. So whatever the documents which are being shared with COC were not being shared to them, because we know that they are also got a right to attend as a participant, isn't it? And similarly is the case with the RA, that he can attend, he may attend the meeting where the plan is being discussed. That is another aspect. So friends, please make sure whenever a plan of say a certain party is being considered, please make sure that RA is given an invitation. Now the second question arises is, because the law very simply says he may attend the meeting of the creditors in which the resolution plan of the applicant is considered. That means, can he attend, can he remain present when everything is being discussed in the COC meeting? The answer is no, naturally. So you will allow him only when his plan is being considered, and he will not be, a participant for others. Naturally, that cannot be permitted. So we'll have to interpret that way. Though law says he can attend, but he will attend only that portion when his agenda item is being discussed. And make sure another thing, because this one another problem has come to another RP. The plan was discussed in, say, 8th COC meeting, and they said, please modify it and submit a new one. And they did not debate about the plan, but they said you should revise it, increase the value. And we will discuss in the next COC meeting. In the next COC meeting, before the next COC meeting, one day before, the RA sends an email to the RP saying that I don't want to revise the plan. Whatever plan is there, now the COC should talk about that, should consider that only. So, and 9th COC meeting was next day. Now, in that meeting, RA was not present, and COC decided to reject the plan. They came to me later. I said, look, it is not that he will attend only one COC meeting, because in the first COC meeting, nothing happened. Obviously, it was discussed and he was asked to revise. But actually, acceptance or rejection of the plan has happened in the next COC meeting. So you should have invited him in the next meeting also. So please make sure, friends, in wherever his plan is being discussed, whether in 2 meetings or 3 meetings, the invitation should be extended to them. This is very, very important, friends. Don't make a mistake that, oh, it was debated in full in this, he was only asked to revise and therefore he did not revise, therefore the COC rejected it. No, that logic will not cut ice, my dear.
Principle of natural justice.
Natural justice, and also, friends, I think we need to be on the right side of the law. I always use a word, abundant caution.
Abundant caution.
I mean, that's what will protect you, my dear friends. Otherwise, it will not. Then otherwise, you will need a lawyer like me to defend you, which I don't want. I'm sorry, I'm telling you. I'm sorry to hear this, but 7 to 8 cases are landing on my table in every month, IBBI's matters. I'm not happy about it. I'm taking their cases because they are my fraternity. I have to defend them, but I'm not really happy about it. So anyhow, so therefore take legal advice before rather than later. So it is very important. Prevention is always better than cure, isn't it? Okay. So this is one part of it. Now the second is, most of the suspended directors, and we will include the RAs also, they were only given minuscule kind of a notice, was only given, no agenda papers, nothing, no details were handed over to them. One of the suspended directors, Mr. Vijay Kumar Jain, he went to Supreme Court. Ultimately, the matter went to the Supreme Court. And Supreme Court in Vijay Kumar Jain versus Standard Chartered Bank, this is one of the famous judgments. Supreme Court Justice Nariman has given a detailed finding in that judgment, and he says there is no difference between the members of the COC and participants, because the argument we given was that these suspended directors are only participants. They are not entitled to vote. And I think most of the RPs who were at that time, I think, you see all the senior persons here, or those who have been practicing like Mr. Ravi Chandran, Mr. Rajkamal Sarogi, I think we all know that initially these suspended directors were asked to go out of the COC when probably you were discussing the plans, or when you were discussing the valuation report and you were discussing avoidance application, isn't it? Every time all RPs were finding, Mr. Suspended Director, you go out of the meeting. Now, after this judgment of VK Jain, my dear friends, they will not be asked to go out, because they are entitled to know and they are entitled to contribute. And Supreme Court says, friends, they are the best people to analyze a resolution plan.
Correct.
They have been running the company for the last 30 years, 40 years. So they will be, their involvement in the COC is fantastic, because their experience will count, whether this plan is good, bad, whether you take that into account or not, because the decision lies with COC. That's all. Nobody is denying that, because they don't have a right to vote, but they have a right to speak. So therefore, my dear friends, please make sure that all suspended directors are given complete set of papers which are being given to COC, the complete notice, complete agenda, and they are heard, and they have got a right to speak. and they've got a right to attend for all matters, including avoidance applications also. Don't send them out. Please do not do that. Okay. If you are doing that, tomorrow there can be a case. So I don't want that situation to happen.
Sir,
So
I
this
have
is
a question. Sir,
yes,
can
sir.
I raise question at this stage?
Yes, sir. You are most welcome.
Sir, that means the valuation report and all resolution plans have to be given to the suspended director as well?
Absolutely, sir. Because the Supreme Court has dealt with this. In this judgment, they have given one paragraph. What does they say? They say, have you obtained non-confidentiality certificate from them or not? What is your problem? It is confidential. They are not going to disclose it to anyone. It is for their consumption and their comments on that. So therefore, it is very important, sir, that you have to provide all documents to them. Whatever documents you are providing to COC, naturally those documents have to be provided, right? So this is extremely important. Okay. Because you see what happens is tomorrow on this basis only some complaint can be filed against RPs. Now, why do we want that situation to happen? So therefore, we should be very, very careful when we deal with these aspects. Okay. Now, let me deal with two very critical questions, right? Now I'm coming to the end and coming to very critical questions. Number one, at what stage the plan can be withdrawn by RA? Right? First, before I give my opinion on the basis of the judgments, because there are a lot of judgments on this account, I would just like to ask the opinion of my friends. Now, here I will divide the question into 2-3 parts. First situation number one, plan submitted, not yet considered by COC. Can that plan be withdrawn? This is the first situation. Situation number.
Yes.
I don't want answers right now, sir. I'm giving you situation. Then you give me with logic, sir. Don't say yes or no only. I want reasonings also, because we understand reasonings and conceptual understanding comes from that. Number one. Number two, situation number two. Plan submitted, approved by COC, pending before the adjudicating authority. Can it be withdrawn? Situation number three. Plan approved by the adjudicating authority. Can the RA now say that, sorry, I am withdrawing from the plan because it is non-implementable, because you have taken 4 years to approve the plan? So these are three situations, right? Let's go one by one. So situation number one. Yes, sir. What is the opinion?
Yes, sir. RA can withdraw in situation one.
And
because plan has not yet approved by the COC. So before approval, it can be withdrawn easily.
Okay.
And
Okay.
in second situation, during the pendency of this resolution plan before AA, it can be withdrawn or it cannot be withdrawn. There can be both situations. Like in COVID period, such situation has arisen. Before COVID situation are different and after COVID situation was different. So in that situation, some resolution applicant filed for withdrawal of the application, withdrawal of the resolution plan, which was disapproved by the AA. Then matter goes to Supreme Court also. Then Supreme Court also disallowed for withdrawal. So in some cases. So
what you're trying to say, we have not understood.
Sir,
if you say they were rejected, that means they were not allowed to withdraw. No, that's what you are saying.
Yes.
So therefore, because in the initial you said they can be withdrawn, they cannot be withdrawn. Both the things can be there. So we are a little confused on that.
Sir, if subsequent stage, as you said during discussion that IM is wrong, if subsequent stage it is found that the IM was wrong, if input was wrong, then output will also be wrong. On the basis of which the resolution plan was approved by the AA and subsequent it was found that IM was wrong, then it can be withdrawn.
Right. Mr. Jain, are you coming from any judgment or are you saying only on the basis of what we have discussed today?
I do not remember the name of the judgment, but I have read certain this kind of.
Okay. Friends, we are only discussing right now. This is not the final view of anyone, right? So we are only discussing, right? So please take it with a pinch of salt. Now the third situation. And in the second question, there will be another question which will come, which I'll talk about a little later. Yes, sir.
Sir, in one of the resolution where I participated from RA perspective and submitted a resolution plan, that was a pretty big case.
Okay.
The IP made me write, when Mr. Jain was saying that if there was something wrong in the IAM, then at a later stage, I will be entitled to withdraw the plan. When I was submitting the resolution plan, IP made me write in that resolution plan that I have carried out my due diligence in submitting my resolution plan. Now my query comes from this. If I were to write and consider that I'm submitting a resolution plan and representing the RA as a sort of advisor, so if I'm incorporating or if I'm made to incorporate a clause like this, that I have carried my own due diligence whilst submitting the resolution plan, would I be, if I am so entitled to withdraw the plan, be entitled to withdraw the plan in case something comes out of the IAM?
Okay. Okay. I'll answer that. But
One thing more here I want to add here, that resolution applicant can withdraw the resolution plan in second situation and third situation also if resolution plan contained the provisions of force majeure and force majeure circumstances occur post submission of resolution plan.
Okay. Okay. Anyway, so there is a third situation which says whether the plan once approved by the AA can be withdrawn or not. So friends, let's understand the legal position now, right? Whatever we have discussed, don't take it as a true legal position. Let's discuss the legal position. Number one, there are judgments to this effect, and this is very logical also. If I submit a plan has not been approved by the COC, naturally I'm entitled to withdraw. I can withdraw that plan, I can modify, I can revise, I can do any damn thing, isn't it? I can say that I don't want to be participated and please do not consider my plan. So therefore, that is possible. The second situation is very critical. COC has approved the plan. It is pending for adjudication before the adjudicating authority, whether such plan can be withdrawn or not. Now, that is a very, very important question which needs to be answered. For that, we have got a Supreme Court judgment. I think everyone should be aware of that. EBIC's judgment, right? EBIC's judgment is there, which very clearly says in Educom case, which very clearly tells us EBIC Singapore Private Limited versus Committee of Creditors of Educom, and this is a Supreme Court judgment. If you wish to note the citation, 2022 2 SCC 401, and this judgment is of 13th September 2021. Now the issue in that case was whether withdrawal or modification. Now there is another aspect, modification. I'll come to that modification a little later. By the successful resolution, applicants are permissible under IBC. Whether a resolution applicant is entitled to withdraw or modify a resolution plan once it has been submitted by RP to AA before it is approved under section 31. So these were the two questions which were framed. And the Supreme Court in effect has held that in any case we are holding that the existing insolvency framework in India provides no scope for effective further modification or withdrawal of COC approved resolution plan at the behest of the SRA. And once the plan has been submitted to the adjudicating authority. Now here comes another situation. And now in a middle situation now. Plan submitted, plan approved by COC, but not submitted to AA. Can this plan be revised? The answer is yes. Because till the time CIRP is continuing, COC is entitled to do any damn thing, because after negotiation, some things may change. Like I'll give you one example, particularly in case of home buyers cases, KV developer judgment came. Now, the RP did not take into consideration KV developer because the judgment was not there. So plan was submitted, plan approved, filed with adjudicating authority. Now here comes a judgment. Now, if I don't follow that judgment, naturally AA will reject that plan. So therefore, what I advise, because now you can hold a COC even after the CRP period is over, but there is a catch. The provision says you can hold a COC meeting, but you will not discuss the resolution plan. Now there is a catch. So now we have to balance two things. That IBBI says you can hold a COC meeting, but you can't discuss the resolution plan. But here there is a KV developer judgment. If I don't follow that, my plan will be rejected tomorrow. So I weighed both the things and I said, this judgment will override these regulatory provisions because this is something which I'm doing as per the law. This is binding. So therefore, we held another COC meeting and we modified the plan in accordance with the KV developer and filed a modified application or maybe a supplementary application to the adjudicating authority, which is still under consideration, it's not been approved. So this is the way which we found out. But the law as it stands today, my dear friends, is they say once you have submitted the plan and it's been approved and it has been submitted to AA, consider these three situations. Submission to AA is very important. Once that plan is submitted, it cannot be withdrawn. Because even there are judgments which say that adjudicating authority also does not have any power to modify the plan. Can you believe this? Supreme Court says, or NCLAT also says that you can reject the plan or can accept the plan. But you cannot say that I will modify the plan accordingly. He says you don't have the power to modify.
Sir, I have a question.
Yeah.
Which I put in the chat box. If the plan has a term that in case of inordinate delay in approval of the plan by the adjudicating authority, say 1 year, the RA reserves the right to withdraw.
Okay. So what you're talking is something different. You're talking about conditional resolution plans. This is a condition, right? I will come to that because I was saying I'll discuss two topics. I've got a lot of judgments on conditional resolution plans also. So first, we are talking about withdrawal, right? So whether they will be allowed to withdraw or not. So I have given you a judgment of Honorable Supreme Court where it says that it cannot happen, right? And modification, alteration after approval of resolution plan by the COC and before approval of adjudicating authority is not justified. And in fact, there is an NCLAT judgment also, which is recent judgment. You can download it, 13th June 2023. 13th June 2023, NCLAT Chennai. And the case is Dr. Ravi Shankar Vedam versus Tiffins Berites Asbestos. I can give you the appeal number. I think that will be easier. This appeal number is 134 of 2021. Okay. And the judgment date is 13th June. So they have relied upon that EBIC's judgment and they said, sorry, it cannot be done. Right. And in fact, you'll also remember that there is an NCLAT judgment of December 2022, which is Kalinga Allied Industries, again on the same lines. So as far as withdrawal is concerned, my dear friends, we are absolutely clear. Withdrawal to the resolution applicant is not permitted under the law after the plan is approved. Right? That is one. Now coming to a second question relating to this. That whether conditional plans can be approved, like our friend Mr. Amarendran just now mentioned, that there is a clause that if this is not approved within a period of 2 years or some time frame, because everyone wants to be approved within a particular time frame. I mean, people are right in saying that, but whether such conditions can be put, now that's a big question. So before I answer that, I would just like to ask the participants, our friends, what is your opinion based on the judgments only? I mean, let's not talk generally. Let's talk about if you have experienced this, or if you have experienced in your case, if that is there. Because there are judgments for and against both. Now that's very unfortunate. We don't have you can say a concrete judgment of the Supreme Court, right? So what I'll do is I have got one, Word file. I'll just try to share that. And then I will share that file also, or you can note down because we have compiled certain cases in the form of this thing. Yeah. Okay. I believe you can see this now, Word file. Right. So these are the judgments which are against this proposition. Now, what is the proposition? Conditional resolution plan. Conditional resolution plan. So this is a judgment of 25th May 2023 NCLT Bangalore bench. Now, whether the conditional plan can be approved or not. So this particular Bengaluru bench says it cannot be done. So in this particular judgment, they say, sorry, conditional plans cannot be. It is a settled law. Therefore, they are quoting this. It is a settled law that the conditional resolution plans cannot be approved under the code, and such resolution plans would diminish the objective for which the code was enacted. If at all this plan is approved, it cannot be effectively implemented. The proviso to so and so. But here the condition of was very you can say fundamental to the implementation. That unless we receive this approval, this will be conditional upon that receiving the approval. So they said, sorry, this cannot happen. So all what I'm saying is that your plan, when you're an RP, please make sure that it is completely unconditional. That is very, very important.
What about, sir, force measure?
Sir, force measure तो किसी के हाथ में नहीं है ना.
हाँ तो मतलब in that case,
sir, force measure तो अब वो condition है ही नहीं ना, sir. Please, let's not discuss. Force measure is something which is not in your hands, right? Which is not in your hands. Supposing the corporate debtor is engaged in a business tomorrow, that business is declared as illegal. So naturally, it's a force measure clause, isn't it? या पता चले वो फैक्ट्री जिसके लिए आपने प्लान ले आए थे वहां पे फ्लड आ गया और पूरी की पूरी फैक्ट्री निकल गई. अब वो क्या प्लान अप्रूव होगा? फोर्स मेजर हो गया ना. फोर्स मेजर इज सम कंडीशंस व्हिच आर नॉट इन योर हैंड. सो लेट्स नॉट डिस्कस दैट. वो तो फोर्स मेजर तो whether you write or not, it is applicable, isn't it? Okay.
It is like this, subject to the approval by AA, subject to approval by the COC. So these are like that only. Force measure is subject to like this. Question does not arise. It goes without saying.
Oh, ठीक है. Subject to the approval of the AA, तो ठीक है. That's all
Yes.
right. That
So
is
that's
all.
not a conditional. That's what I'm saying.
That is not considered as a condition. Obviously, that is subject to that. Naturally, the whole plan is subject to the AA.
True.
Whether you write it or not.
Correct.
And therefore, this is another judgment of NCLT Ahmedabad bench, 6 July 2022. This is the judgment M2K developers. Again, they say resolution plans cannot be conditional, cannot be approved. But here, surprisingly, there are few cases which are there. Of course, we have quoted one Supreme Court judgment, but that is not very concrete on a particular aspect. What in that judgment, what has happened is the appeal was filed, the Supreme Court dismissed the appeal. So now somebody can say this has become a law, but I will not like to say that. Okay. So let's consider the other judgments more important. Now here, this was a judgment of NCLAT, again, of 25th May 2023. Now, what it says, this is what this NCLAT has. NCLAT upheld approval of a conditional resolution plan by noting that while a conditional resolution plan could be allowed, any condition which allows a resolution applicant to seek suitable modification to the resolution plan or withdraw the resolution plan are unenforceable. Are you getting my point? I think this answers Mr. Amarendran also. So they say conditional resolution plan can still be approved provided that condition does not empower the resolution applicant to withdraw the plan or to modify the plan. So this is a modification or withdrawal is not permitted. So this is what the court has mentioned out here. Okay. And then, of course, there is another judgment of NCLAT. So I'll share all these three judgments. I don't want to read, you see, this thing. But the fact is, some minor, you see, conditions have been approved. And they say, in fact, in this judgment also, they are writing, NCLAT is writing, the given resolution plan is conditional. But since according to the express directions given by the Supreme Court in various cases cited above, the adjudicating authority per se will have to go to the commercial wisdom of the committee of the creditors. So here there is a judgment which says that, look, it is the commercial wisdom, whether it is a conditional plan or not. Who are you to look into this? So this is something, so we'll have to see what kind of conditions are being put. Whether that condition is allowing the person to withdraw or modify, that will not be permitted. So we'll have to see. So the law is not very clear at this stage. Of course, there are judgments for and against. So, but it really depends. So what we are saying is it will really depend upon the type of the condition. What condition you are stating. So I think somebody has to form a legal opinion on that. And then, of course, the call has to be taken whether that will be treated as a
Sir, sorry to interrupt, but the most common condition, especially in real estate, is approval by planning authorities or whatever. Because without that, the plan is anyway not workable.
No, that's all right, sir. But you see, the point is, that condition will probably not be here, because then this is giving a chance to withdraw. So what, see, if you are taking a responsibility for implementing a project, naturally it is subject to the different government approvals. Supposing you are taking over a manufacturing industry, don't you think that you will have to take environmental approval also? Now tomorrow you can say, oh, it is subject to the environmental approval. Supposing approval is not given, you say, I'm withdrawing. No, that cannot be permitted, because this is a business call. So
Understand.
if you are taking over a company, naturally you will have to comply with the laws of India and all these statutory authorities. And don't you remember, sir, when we used to go to merger applications? Do you remember those period when High Court was approving the merger applications? People used to say in the merger applications that once the company A merges into company B, we will not pay stamp duty on this. Stamp duty should be exempted. So initially, High Court started giving that because that was a part of the scheme. But later on, the court realized that this is something which is wrong. So they say, no, you will have to follow the law of the land. As far as stamp duty is concerned, we are allowing you to merge, but it is not conditional upon the waiver of the stamp duty or not. You approach the state government, if they allow, fine, otherwise you will have to pay. So anyway, I think
okay, sir, but one last thing, understand, but at the end of the day, it is the COC which approves this.
Correct.
I as RP tried my best on this.
No, sir, I think you should have mentioned that, look, it is not in accordance with the judgments of the Supreme Court.
In the Form H, I have mentioned this particular.
Because see, our duty is to point out. Tomorrow, if any finger is raised upon you, IBB will ask you, did you point it out to the COC? Did you discuss this in COC meeting? Because minutes are the evidence.
Yeah.
So make sure.
And the Form H and the application where you forward to NCLT, you have to disclose this.
Absolutely, absolutely. Those things are definitely there. Okay. So friends,
Sir, in stamp law, in the stamp duty case, like in transfer or merger, here exchequer or registrar, sub-registrar are not familiar with the merger acquisition. And in that case, they will straightforward say, we are not aware, you have to pay duty. That is their simple answer.
Well, you see, there is another question which is coming now. Because right now, most of the state stamp laws or stamp rules were silent about the IBC takeover, right? They were talking about mergers, acquisition, and all those stuff. And they were very particular about, taking a stamp duty on mergers or amalgamation, but they are silent about IBC. Now, after this, they have risen. So now they are saying the moment it is approved, now you will have to pay us because it involves transfer, it involves this and that. But anyhow, that position is still not clear. And according to me, even, right, if you want to seek a concession in the resolution plan, seek it. Because concession you can always seek, isn't it? And the NCLT has got power to give concession and relief. So you can always seek that. If it is a part of the plan, then nobody can demand it. But anyway, you are right. This issue is to be decided by the Supreme Court. Okay. So friends, there are some queries are there. Let me take up one by one. I don't know where to start from, what I missed. Jan sir, can you help me on this if I missed anything? Okay,
Yes.
let's start from
Shall I read the question?
Yes, let us start from the latest one then. I think Mr. Ravinder Chaturvedi. Arey Chaturvedi sahab, aap apni video on karo na, you can ask a question. Yeah. Let's meet after a very long time. Why are you asking question on a chat box? Okay.
Neither I-flu virus nor COVID will travel, even if you open the window. Don't do it.
Yes, sir.
Yes, sir. Ravinder ji, how are you?
Sir, first class, sir. Nice to hear you, sir.
No, it's always a pleasure to meet all my friends. Okay. So what is your question, sir? Can you ask?
Sir, actually, I am facing this practical problem.
Okay.
In one of my case, the resolution plan was could not be implemented because of the RA has not made the required payment.
Okay.
And now the monetary committee has decided to take that company in liquidation. They have filed recently the liquidation application also.
Right.
And made me as a respondent. I don't know why they have made me respondent, but they have made me respondent.
Because you are the chairperson of the monitoring committee.
No, I'm not the chairperson. Chairperson is somebody else.
Achha,
because it's a very critical case, I don't want to be a part of that committee also.
Okay.
So even I was not in monitoring committee also. And I have said clearly that I don't want to be a liquidator. That is why they have appointed some other liquidator in this case.
Understood, sir. Understood.
Yeah, my fees is stuck up in this case.
Right.
So I want to utilize the performance guarantee amount to take my fees. And the COC is hesitated. They want that first let the liquidation order pass. The money should come to liquidator, and then he will disburse that money to you.
So I will also advise you the same thing.
Yeah.
Don't do that, sir, because you see, it may be a part of the CIRP cost. It may have a preference or priority, but you will wait the order of the NCLT. Don't do that, sir, because tomorrow there can be a complaint against this. So please, I'll advise you not to do it, sir.
But the law, as far as I understand, sir, in RFRP also we have mentioned that once the resolution plan is paid, the performance guarantee amount should be forfeited, right?
But that is a separate issue.
Yes.
In one of our cases, the plan got not implemented. We forfeited this. But what I advise the RP, and RP has done a fantastic thing. I advise the RP to keep this money in a fixed, because she was also a chairperson of the monitoring committee. So it has been kept separately in a fixed deposit, and this money has not been used so far. Because the other person has challenged the failure. So supposing he's put back into the original position, then what will happen?
I got it, sir. I got it.
So therefore, have an abundant caution, as I mentioned earlier. Abundant caution.
Okay, sir. Thank you so much, sir. Thank you so much for your guidance, sir.
It's a pleasure. I think Mr. Deep Kumar Vagela, sir, आप भी अपना video open करके बता दो, sir. What do you want?
So basically, I think you have answered in a couple of questions.
Yeah. Okay.
So but in that, I have mainly two questions. First is what type of guarantee or indemnity an RA should take for practical implementation of a resolution plan. And the second one is in the resolution plan, can we take that the pending litigation or proceedings or any kind of inquiry or uncrystallized liability should be extinguished and it should not be paid post approval of a plan?
Okay. So I'll answer your second question first. Sir, friends, may I request everyone to just please mute for a moment. I think there are some background noises coming.
Ambesh Biani, Mr. Ambesh Biani, please mute yourself.
Sorry. Okay, so the second question I will answer, insofar as the uncrystallized liabilities or those people who have not filed claims or litigations going on or say attachments going on by the government departments, friends, section 32A is very clear. That supports you. 32A on the statute books. It gives you immunity to the RA. What does it say? It says in the 3 terms. Of course, it's a very long section. I'll just give you very briefly. The first subsection says immunity is granted to the corporate debtor from being prosecuted by the enforcement authorities or any authority against any legal cases. So it shuts down everything. Second, if any property has been attached, say enforcement directorate or CBI or whatever authority has attached certain properties, so that attachment will also be detached. So that means that will be negated. So the RA will get detached properties. It cannot be continued to be attached. But the third subsection says that this immunity will not be extended to the employees or the suspended directors who are also parties to that inquiry or investigation. So the benefit is going only to the corporate debtor, provided there is one more condition, provided the resolution plan is approved by the RA, and 2, there is a change in the management. If the same management is continuing, then 32A immunity will not be given. So if there is a change in the promoters, then naturally this immunity comes. And in any case, sir, even under section 31, we know that the resolution plan is binding. So there are no uncrystallized liability will be taken into account, right? We have got a lot of judgments on this Ghanshyam Mishra. That is wonderful judgment, which says all previous liabilities not been included in the resolution plan, not required to be paid. Supreme Court judgment. Now, coming to the first question, I would like to ask you, what is your exact question? Because you mentioned about what guarantee the RA can take. I mean, I have not understood the question.
Yes, so
I
am a successful resolution applicant now, and I need to have that implementation resolution plan now. So should, as a part of should we take any kind of indemnity or kind of guarantee or kind of any insurance to, so that we can have at least some control for any kind of liability in future exists, because of we don't know, either we have not mentioned the resolution plan or something can happen on practical ground.
No, we have understood. Now tell me, you're saying what guarantee or indemnity? आप किससे guarantee लेंगे बताइए? Plan, see, once the plan is approved, you are in the saddle. You become the owner of that company. अब कौन guarantee देगा आपको? RP देगा? बेचारा RP तो पहले ही मरा हुआ, उसको फीस तो मिलती नहीं है. So there is no guarantee. Guarantee is the approval of the adjudicating authority. Look at section 31. It says plan is binding on everyone, including the government authorities. That is the most fantastic guarantee which you are getting. और अगर आपको implementation में problem आ रही है, right? If you are facing any problem,
yes,
law supports you. He says you can come back to NCLT and get a direction against the people who are not complying with that, and you can file contempt also. So इससे बड़ा guarantee क्या है, sir? Court का stamp is the guarantee, isn't it? It's otherwise it's a business call, sir. It's a business call. Whether you are able to implement successfully or not, it's your business call. So nobody will interfere in that. Okay. Okay. So friends, I think we have almost crossed our limit today of the time. I would have very well like to have more questions. Anyway, we can have a last question if anyone wants to speak or share their experiences, right? Or share your experience for today's program also.
Is there any income tax aspect of this resolution plan? If there would be any income tax on extinguishment of liability?
Sir, income tax is a different subject altogether. I think we have had certain seminars. I would request ICSI, IPA to hold another program on GST implication or income tax implication on extinguishment of liability or not. So please look at, you see various provisions of income tax, my dear friend. I think you, if you are a chartered accountant, you better know than me, right? So otherwise, I think we have conducted so many programs on that. Whether it will tantamount to extinguishment.
I have seen that, I have heard that income tax department has served notice that there was extinguishment of liability and they were liable.
Okay, let me answer this very quickly. As far as past liabilities are concerned, it will be governed by the resolution plan, number one. Number two, if you're talking about remission of liability, whether you see supposing you are taking a haircut, will it be added into the income or not? I will only give you 3 sections, my dear friends. Just read that. I think that things will be clear. Please read section 41(1), 28(4), and 56(2), clause number 10 of Income Tax Act. If somebody can write in the chat box, sir, I'll repeat once again. Section 41(1), it deals with remission of liability. Section 28(4), here Mahindra and Mahindra judgment is applicable. And lastly is section 56, subsection 2, clause number 10, waiver of loan. So please read these 3 sections of income tax, and I think things will be clear. Otherwise, we can have a separate session on income tax on these things, right? Okay.
May I ask?
Sir, I have one query. Whether the suspended director is eligible to submit the resolution plan if the RP has filed an application, preferential application, against the suspended director, and the said application is pending before the NCLT, and the company is under MSME registered.
Okay, good question. Good question, Rajiv ji. I think it's a very important and significant question you have asked. Well, if you ask me, if you look at section 29, because ineligibility is to be seen in accordance with 29A only, right?
Right, sir.
What does it say? It says if an order has been passed against the persons for recovery under avoidance transaction. So merely pendency of the application will not disqualify.
Agreed, sir. Same
right?
Right. Thank you. Thank you, sir.
Yeah, okay. So friends, I think it has, okay, somebody has asked for that High Court judgment. Friends, I will not be able to do it right now. Maybe, okay, how do we go about it? Because there is no common WhatsApp group here to share. What I'll do is I'll
Sir,
share.
you can share the same over mail with me.
Okay, that's fantastic. So
I'll share the same with the participants.
And this word file also.
Yes, sir. Yes, the
If I
word
could
file
be
and the
excused for 30
presentation which
seconds,
you have
sir.
shared. So you can share all those things over mail with me, and I'll share it with the participants.
Okay. There are 2-3 people who want to speak. Yeah, one by one.
Sir, just only one thing. Ravichandran here. Just now, Mr. Rajiv asked one question. In Chennai NCLT, if the section 66 or 43 application is pending, they are not approving the resolution plan till it is disposed of.
That's all right. That is one view, but they are eligible. Please understand. As far as
they are accepting that, but they say that I will not approve the resolution plan till we determine that.
Sir, bench members are smarter, sir. I can't comment on their this thing, sir. I think they are all honorable members and they can hold this view. Yeah. In one of our cases in Chennai bench itself, sir, I don't want to say, we filed a merger application prior to CIRP. In between CIRP was filed. They put a stay on the merger application. First, we will decide CIRP application. Which law says so, sir? But anyhow, one can always go in an appeal. Yes, sir. Anyone?
Yes,
okay. Somebody was asked for the template also. I understood, right? So template, word file, and High Court judgment, and maybe some more judgments. Okay, I've got it.
Thank you very much, sir, for enlightening this session.
Wonderful.
Very
Thank you.
informative, very practical.
Payment of resolution amount. What is happening is FC is ready to condone that delay.
Sir, can you repeat your question in between? I think there was some over speaking, so we could not get your question, sir. Can you repeat it?
Sir.
Yes, sir.
The resolution plan is passed. First installment is already paid. All the OCs paid. Whosoever could not be paid, his money is lying out there in the account. So my one question is, because the account of those people have turned dormant or they have closed the accounts, and right now I'm unable to reach across to them. That's how their money is still lying in the account. That is part number one. Part number two is now second installment was due. This SRA could not make the payment in time, and he asked for condonement from FC. FC is ready to condone that. So anything to be done at my end, or any waiver to be sought from NCLT or any other.
Okay.
Thank you, sir.
Okay. Good question. You see, the same problem was faced in one of our circumstances where he paid some amount and then he said, because of COVID, I need 1 more month. And SCC typically allowed 3 extensions, right? One month. And even then the plan was not complied with. And then naturally after that, this thing is there. But I remember one of the judgment reading in another case, SCC allowed or COC allowed some extensions. The court NCLT said they did not pass any stricture. They said SCC never had the right to allow the extension. Having done that, still he is not paid. So therefore, we treat this plan as failed. But they have mentioned one sentence that SCC did not have right to allow extension. Only we have the right to extension. So I will suggest you, sir, to be on abundant caution, advise them to approach the NCLT for any extension. You say SCC do not have any power to extend unless the plan says so. Agar plan mein ye likha hai ki SCC can extend for some time or something like that, I don't know. So you'll have to read. Okay, yes, sir.
No, in this particular case, there was no mention. This is not a liquidation matter. This is CIRP matter, and the
CIRP matter. I know that.
Yeah.
I know that.
So in that case, FC says
so let's not say SCC. Let's say COC. Okay.
Yes.
It's a monitoring committee. It's a monitoring committee, right?
Absolutely, sir. So under section 33(3), they are saying it's the right of the FC, the affected party. It's the call of the affected party. In this particular case, the FC. FC says okay, he's asking for 1 month, and the committee is saying okay, levy some interest for that particular period, and in case he's ready to rectify that thing, we are ready to fly with that. So I have taken note of that in so many words in the MC minutes.
Here, sir, you see, the point is 33(3) talks about liquidation. that if there is a contravention of the plan, any aggrieved party can approach the adjudicating authority for ordering of liquidation. That is a right which is given to them, right? If you are talking about extension, right, then here the resolution applicant will go under section 60 subsection 5 and say, please allow me extension. That is what I'm saying. Here, it's not a case of, see, if financial creditor is aggrieved, they want to go and start the liquidation, that's their right under 33(3). Nobody is stopping them. But as far as extension is concerned, now here the person concerned who is seeking extension, he has to obtain an extension from an appropriate authority. An appropriate authority, according to us, is not the monitoring committee, but the NCLT, which has approved the plan. Okay, hope I am clear, sir. Okay. Great,
Thank
sir.
you, sir. I would like to say one thanks once more for advising me, because in one of the cases, CD or suspended director has sold property of the CD during the CRP, and you advised me to file an stay application as well as different application for cancellation of sale deed, which worked, and I got the stay. So thank you very much, sir, for your advice.
Sir, अब जैन साहब अपना एड्रेस बता दो, बिल भिजवा देता हूं.
Most.
So thank you, Ashish sir, for this wonderful session. These 3 hours must be enlightenment for all the members, all the participants who have attended this session. And it's always like to have knowledge from you. It's been wonderful in all those sessions. So thank you so much for catering our request and spare your valuable time for the participants of ICSI IIP for this session. So formally, I would like to place a vote of thanks to our today's faculty, Ashish Makhija sir, and to all the participants who have participated in the session so enthusiastically, sir, so that these 3 hours are like, yes, we can share the knowledge from each other. Thank you so much, sir, and thank you all the participants.
Madam, have more of Mr. Makhija in coming times, please.
Yeah.
Thank you, sir. Thank you.
Thank you so much.
Thank you, sir. Thank you very much.
Thank you very much, sir.
Thanks. Thank you, sir.